Mr. Van Rijn, you're still under oath. Thank you, Ms. Swanepoel.
Good morning, my lord. Good morning, Mr. Van
Almost
Rijn.
called you Lombard again.
Good morning, my lord.
Today, I'm just going to focus on contradictions, things that are different between your testimony in chief here and in cross-examination.
Vandaag focus ek slegs op die teenstrydighede, die verskille en u getuienis in hoof en tydens sekretsondervraging
In relation to what was included in the plea explanation
en verband dit wat in die pleitverduideliking ingesluit is,
and also what was put to the state witnesses.
sowel as die stellings aan die staatsgetuies gestel is.
Thereafter, we will deal with the contents of the confession.
Daarna, dan gaan ons dan met die inhoud van die bekentenis self handel.
So, we're going to try to keep this as quickly and short as possible.
Ons gaan probeer om hierdie oefening so vinnig spoedig hou,
Okay,
kort en kragtig hou.
you understand?
Is dit verstaanbaar?
All right, thank you. Okay, so your testimony and what was put to all the state witnesses in this trial within a trial was that you were instructed to remove your sweater
Die getuienis wat by elkeen van die staatsgetuies in die verhoor binne verhoor gestel is dat u is beopdrag om u sweater uit te trek,
as well as your shoes.
sowel as u skoene.
Correct. Although in your plea explanation there's no mention of the shoes.
Alhoewel in u pleitverduideliking word daar nie melding gemaak van u skoene nie.
Do you want to comment to that?
Wil u dalk kommentaar lewer op dit?
No comment.
No comment, my lord.
Mr. Van Rijn, maybe if you can just push your chair slightly forward, closer to the microphone. Okay. I've been shown that they're going to adjust the sensitivity of the microphone. Just so that I can also hear the answer, please.
Sodat ek self die agbare hof ook na die Afrikaanse antwoorde kan hoor, né?
Thank you. There we go. There was no comment. Thank you, Ms. Swanepoel.
Thank you, my lord. Also, sir, your evidence was that when, and this is specifically with regards to Dr. Now, when you were taken to Dr. Now, it was only one police officer who was with you in the room. Is that correct? And that's
Meneer.
Mbovane.
Dit is ook u getuienis die tyd toe u na Dr. Nel se kamers toe geneem is. Binne Dr. Nel se spreekkamer, het was slegs u en net een polisiebeampte. Dit is u getuienis daar.
Correct, my lord.
Okay. Whilst in your plea explanation, it is referred to as police officers, plural, who were present with you.
Toch in u pleitverduideliking word daar na die beamptes in meervoud verwys. Dit word gesê dit was polisiebeamptes.
Just before the witness answers, I can see Ms. Nkabike moving towards the microphone. Yes, thank you, Ms. Nkabike.
Thank you, my lord. The last part by my learned colleague, that the police, they were present. They were present where? If you can finish that, where they were present.
The statement to Mr. Van Rijn is that in his evidence, and we also heard that because of the size of the room, there was only one police officer present,
Yes.
and that was Sergeant
Mbovane.
Mbovane. So she's putting it to him that in the plea explanation, it makes mention of more than one police officer. So, are you referring to paragraph 41 of the... No, I know, but
Yes,
are you
but-
referring
yes.
to the plural
Yes, my lord.
in paragraph 41?
Yes.
Can I just hear Ms. Nkabani's, Ms. Nkabai's comment?
My lord, in his last sentence, he put to my client, but it is said police were present, then full stop. I want my learned colleague to be specific. Where were they present?
The statement put to him was that with the examination of Dr. Nell, his evidence now is that there was only one police officer present. But in the plea explanation, it's reflected as more than one police officer. But just have a seat, Ms. Nkabai,
Thank you, my
because
lord.
I'm not so sure, Ms. Swanapu. Yes, you can split hairs about the gender of the police of the doctor. Right? Because it starts out by the examination in the morning. Now remember, there were two. He says it was in the evening, the next one, but we know it was mid-afternoon.
Yes.
That's Dr. Zimri.
Yes.
He says police officers. Now we know there was more than one with Dr. Zimri. That's not an issue. That's why I took you to 41. Now, 41 follows after the examination in the afternoon. Now, there's no gender mentioned of the afternoon doctor,
No, it's not. It's only in 41. my lord.
only in 41.
Yes.
So I'm gonna allow the question, but nothing will turn on it because it can be interpreted that it might refer to the first one or the second one. I think leave that question. Let's pass. Not make a song and dance about it now, because it can be confusing. Remember, even the doctor, Dr. Zimri, just for completeness, she thought what she was doing was a post-confession
Yes.
examination,
Yes.
whilst it was a pre.
I will leave it, my
Yeah.
lord. No problem. I abide. Mr. Van Ryn,
Meneer van Ryn,
however, your plea explanation narrates events of the 6th of March.
wat ook al u pleitverdediging vertel die gebeure van die 6de Maart,
And I'm specifically referring to paragraph 43 there.
in besonder paragraaf 43.
Now, here it also refers to an examination, doctor's examination that you went. Same story, you didn't want to tell the doctor because you were in the presence of police officials.
Daarna word ook melding gemaak van die feit dat is deur 'n dokter ondersoek weer eens waarin nie openlik met die dokter praat nie, want dit was in die teenwoordigheid van die polisiebeamptes.
You were never medically examined on the 6th of March.
You were never.
Medically examined on the 6th of March.
Op die 6de Maart is u nooit medies ondersoek nie. Dat is weer die dokter gewees die 6de Maart nie.
Is that correct?
Reg so meneer?
Is hier ik denk ik was bij de dokter.
I'm not certain. I think I was at the doctor.
Well, there's no proof of that whatsoever.
Wel, daar is geen bewys daaroor wat ook al.
So I just wondered where these instructions came from.
Ek wonder maar net waarvandaan kom hierdie instruksies.
Would you like to comment?
Wil u daaroor kommentaar lewer?
Nou, ik was bij de dokter.
On the
How
5th
was
of
it?
March.
Op die 5de Maart.
Correct?
Reg so?
Is correct, ja.
Not on the 6th.
Nie en nie die 6de nie.
Ik kan nu nou.
I cannot remember.
All right. I'm going on.
Ek beweeg aan.
Why was it in your instructions that the reason why you were taken to Vredenburg Hospital for medical examination was because of the injuries you had suffered and not because of the fact that it's procedure before a confession?
Terwyl dit u instructies gewees het dat die rede hoekom u na Vredenburg Hospitaal toe geneem is, dit is as gevolg van die beserings wat u opgedoen het en nie die voorbekentenisprosedure nie.
Where did those instructions come from?
Waarvanaf kom daar instructies?
Ik was dokter toe voor die confession was.
I was
Yes.
taken to the doctor before the confession,
Twice.
2 keer.
Alles met jou wordt dokter toch wat.
They themselves took me to the doctor.
Yes, because as they testified, it's procedure.
Bereg net soos hulle getuig het, dit is prosedure.
Alles met dokter toch wat voor de beserings.
And they took me to the doctor for the injuries.
Colonel Clark's testimony specifically was very specific to this. It's
Colonel.
procedure, it must be done.
Clark se getuienis was meer spesifiek op hierdie punt. Dit is prosedure, derhalwe moet dit gevolg word. Dit is iets wat moet gebeur.
And when he testified that, it was put to him that you were not taken because of following procedures. You were taken because of the injuries that you had sustained due to the torture.
En tydens sy getuienis is dit aan hom gestel dat u is die dokter toe gaan neem vir daardie doeleindes nie. U is slegs dokter toe gaan neem vir die besering wat u as gevolg van die marteling opgedoen het geneem.
Ik was dokter toch wat ja.
Dit is korrek, was taken to the doctor.
Do you want to comment about the fact that those instructions were put to Colonel Clark as
What?
being the truth?
Wat sê u oor die feit dat daardie instructies is aan kolonel Clark gestel as die waarheid? Wat sê u dat van daardie instructies is aan kolonel Clark gestel as die waarheid?
Als je waarheid ja.
It's the truth, yes.
So why does that truth then differ from the truth that you testify now?
Hoekom dan nou die verskil? Hoekom verskil daardie waarheid met die waarheid waaroor u tans besig is om oor te getuig?
Je weet niet.
I do not know.
Okay. The plastic bag that was put over your head,
Die plastic sak wat oor uw hoof getrek is,
according to your version,
volgens uw weergawe,
it was specifically put to Captain Lombard that it's
spesifiek aan kapitein Lombard gestel.
that it's a black bag, and the purpose of doing that is so that you would not be able to see the torturers to identify them.
Dit is 'n swart saak en die doel daarvoor is sodat u nie die martelaars kan identifiseer nie of kan sien nie.
Is that correct?
Correct, my lord.
Now, I just want to put it to you and hear your comment.
Ek wil graag aan u stel en ek wil u kommentaar daarop hoor.
You were able to see the people on your version, the 2 men at Jacob's Bay,
Op u eie weergawe, u is in staat om die 2 persone, dit is nou die 2 persone dit Jacobsbaai,
you were able to see the 2 females from Jacob's Bay,
u is in staat om die 2 dames vanaf Jacobsbaai te sien.
you are taken into the boardroom, you see all of these people,
Is na die raadsaal toe gaan neem en u sien almal hierdie mense.
you're taken to the other office, you see the people,
Is na nog 'n vertrek geneem of kantoor geneem. Weer eens sien u hierdie mense.
Then you are taken back to the boardroom and there you are now tortured and a black bag is put over your
En
head.
dan is hy teruggeneem na die raadsaal toe, daar word hy gemartel en die swart sak word dan oor die hoof getrek.
And later on, again,
Later, weer later,
the bag is removed and now you can see again.
die sak is verwyder, weer eens kan jy sien.
Just a moment. Yes, Mr. Kabai.
Thank you, my lord. This statement is too long for the client to understand. If my learned colleague can be short so that my client can understand. Statement that has been put to him is too long, my lord. It can easily confuse him.
Hierdie stelling is te lang vir my kliënt om op te reageer. Ek vra dat my kollega dit korter moet hou sodat my kliënt 'n kans gegee kan word om daarop te kommentaar te lewer. Te lang.
Ms. Swanepoel. No, but Ms. Kabai is correct.
I'll break it up, my lord.
It can be confusing. It can be put in a different way to say there were all these instances where you could see all the individuals, what would be the purpose. And remember, whether it's the swinging or the spinning, the explanation of the accused was also at the chair. Because he was swinging in that particular way, it was easy to put the bag on. So, Mr. Van Rijn, I'm just going to summarize this long question because I understand it can be confusing because there are all these different instances mentioned. But you'll recall you were at Jacobs Bay, different officers. You could see them all except for the times when the bag was over your head.
Correct, my lord.
Good. Thank you.
Thank you, my lord. Now, sir, what would then be the purpose of putting a black bag over your head?
No, meneer, wat sal die doel wees dan om hierdie swart sak oor die hoof te trek nou? Wat probeer hy bereik nou? Hulle bereik deur nou hierdie swart sak oor die hoof te trek.
Ek weet nie om dit te versmoor, ek weet nie.
I don't know, maybe to smother me, maybe to suffocate me.
But on your own version, you were able to bite through this plastic bag.
But op eie weergawe, hy daarin geslaag om hierdie swart sak stikkend te byt.
Correct, my lord.
And then we heard yesterday in your testimony for the first time that then a see-through, a houtsak, was used.
En gister vir die heel eerste keer.
It was a shiny bag.
Shiny.
A shiny bag with no holes in it. But it's the
Shiny
first
bag.
time, the point is, it's the first time that we now heard yesterday about anything else but a black bag.
En gister hoor ons nou dat nou iets anders benewens 'n swart sak is gebruik. Nou hierdie houtsak, hierdie blink houtsak is probeer is gebruik.
Correct, my lord.
Korrek, my lord.
Why did we not hear of this shiny wood bag, houtsak, earlier?
Hoekom het jy of nie vroeër nog van hierdie blink houtsak vroeër gehoor het nie?
Al was ek uit my
I must have forgotten about it.
Or it was something that you only thought of yesterday
Dit
to
is
add on?
dalk iets wat jy gister aangedink het en nou net bygevoeg het,
nee, my lord.
aangelas het.
Goed. I take it that the torture, as you described, being in this position and being hit, you were hit with the same tongvas as Mr. Polis explained.
Ek aanvaar dan dat tydens hierdie marteling hy soek dan nou deur daai tongvas geslaan soos wat met my Apollos die geval so gewees het.
Sorry,
Dieselfde.
The English word is a baton.
A baton.
I forgot it.
Correct, my lord.
Okay. And you were hit the same way as Mr. Polis demonstrated.
Op dieselfde manier soos wat meneer Apollos hier in die hof gedemonstreer het.
Ek kan nie sê nie,
I can't say,
maar ek weet ek was geslat.
but however I know I was beaten.
Hard.
Geslat, ja.
Beaten, yes.
yes. And your testimony today is that you were Your testimony yesterday was that you were beaten on your hands, your knees and your feet.
En gister die getuienis is dat is by hande, knie, voete geslaan. Dit was die getuienis.
Correct, my lord.
And those were where you were hit.
En dis die plekke waar hulle vir u geslaan het.
Is correct, my lord.
You're sure about this?
Is seker daarvan, meneer?
Correct.
Correct.
Okay. Because in your plea explanation,
Want in u pleitverduideliking,
paragraph 36,
paragraaf 36,
it reads, I was hanging in mid-air. A plastic bag was placed over my head while I was hit on my head, legs, feet and hands.
ek het in die liggaam, terwyl ek geslaap gewees het, my bene, knie, hande, kop geslaan is. Met hierdie sak oor my kop.
Is correct, my lord.
You heard that in the plea explanation you also referred to your head.
Het u hoor u dat in die pleitverduideliking voor 'n melding gemaak van u hoof ook?
Ja, ek was ons geklap en geslat.
Yes,
Maar so,
I was smacked and beaten on my face.
You remembered that I asked you earlier whether you were certain.
No.
Ek het u vroeër gevra dat
No, you asked him in relation to the baton. And he mentioned that the baton, it was on those areas. That paragraph does not say what he was hit with.
It doesn't mention.
So if he was hit on his head with hands, it wasn't covered by your previous question.
All right.
So the question is disallowed.
As the court pleases, my lord. It was put to Captain Lombard
dit is aan kaptein Lombard gestel.
that you were motivated to scream.
Hy is gemotiveer om te skree.
is correct, my lord.
I mean, to get them to remove the bag, right?
Is correct, my lord.
All right.
In the context, whenever you want to speak, you had to scream.
Sodat enige tyd wanneer u wil gepraat het, dan moes geskree het
Is correct, my lord.
om aan te dui dat u was reg om te praat.
Okay. Whilst once again in your plea explanation,
Weer eens in die pleitverduideliking,
paragraph 37,
paragraaf 37,
to stop them torturing me, I shook my head and they removed the plastic bag.
Well, in 36, he says, they told me if I want to talk, I must shake my head. Fourth line from the bottom.
Thank you, my lord.
So what was it now? Shaking your head or screaming?
wat was dit nou? Kopskud of skree?
Ek het my kop geskud en geskree.
I shook my head and I screamed.
The question is, what were you told to do?
Die vraag is, wat is u voorgesê om te doen?
Ek moet skree.
I must scream.
So why does your plea explanation then refer to shaking your head?
Maar hoekom sê die pleit verduideliking dat kopskud?
Van al die was ons hier my.
Because both were told to me.
Oh, so it's not only scream, both now we're
So
told.
dit is nie net die geskree nie, beide. Nou is dit beide.
Is correct, my lord.
I'm just pointing this out to you, sir. We will argue that you are adjusting your testimony and your version as you go along.
Meneer, ek lig dit uit aan u. Later gaan ek betoog, dan sê ek u pas u getuienis soos u te werke gaan. Pas dit aan?
Is jy reg?
That's not correct.
There's an Afrikaans saying, jy span jou seile na die wind.
Gaan ek dit nou in Engels oordra?
In other words, as the wind takes you, then you go in that direction. When it comes this way, you go in that
You're
direction.
going with the flow. Yeah, you're moving with the flow.
Before the witness answers, yes, Ms. Mkabai.
Thank you, my Lord. I won't agree with that statement in this context. What he said in his plea explanation is what he's saying even now. He's not going with the flow, my Lord.
Thank you. The objection is overruled. You see, Mr. Van Rijn, and I'm sure it's going to be argued later, there are other instances in your evidence as well. You gave your attorney instructions before the start of the trial, right?
Correct, my Lord.
Also, on those first few days, because we had to make time for consultation and to clarify things and so forth, right?
Correct, my Lord.
But you didn't tell her that you were also told to scream, otherwise it would have been in here. Do you agree?
You must go with it, my Lord.
I must have forgotten about it, my Lord.
Now, just to give you the context, it was clear to me during the evidence that Mr. Apollos said he was told to shake his head and you were told to scream. Right?
Correct, my Lord.
But of course, as things went on, came the story about Mr. Apollos also screaming. So what the prosecutor is saying, as things develop, the instructions change and suddenly new things come on. Do you understand that?
Understand, my Lord.
So is it a question that you forgot or merely that you want to adapt your evidence? That
Forgive, my Lord.
I forgot, my Lord.
Now, just to complete that, because I know it's going to be argued, lest we forget about it, the same applied to the spinning and the swinging of between the chairs. Can you recall the discussion we had yesterday about Dr. Zimri?
Ja, my Lord.
Yes, my Lord.
Now I'm explaining this to you because I've overruled the objection. But when I decide, the prosecutor's statement to you is, you trim your sails as the wind blow. We spoke about going to sea yesterday. See all these sailboats. So they move their sails and adjust it. Do you understand it?
Understand, my Lord.
I understand, my Lord.
Thank you, Ms. Swanepoel.
Thank you, my Lord. It was put to Captain Lombard that you did not sustain your injuries due to falling from a police van.
Dit is aan Kaptein Lombard gestel dat hy het is beserings opgedoen as gevolg van die beserings wat hy opgedoen het is as gevolg van die feit dat hy van die polisie van die polisie van
Just a moment. Did you say police van?
Yes, my Lord.
Because he's what he told the doctors and was that he fell from a bakkie.
Yes.
It was Mr. Apollos who the injuries he told Pretorius in more detail that was caused in and out of the police van. I can't recall that the statement was from a police van, but rather from a bakkie. And
My
Yeah,
Lord, I'm referring very specifically to the cross-examination of Ms. Mkabai of Captain Lombard. Specifically after the adjournment, she asked for an adjournment. There was an adjournment.
Oh.
Thereafter,
now, when was that?
my Lord, I will give you the date. On the 1st of April. After lunch, we adjourned from 12:40 to 13:30. After lunch, before he got a lift from the police, he had no injuries. Before the interviews happened, he had no injuries. The injuries he sustained is not due to falling from a police van. The reply thereto was, I never saw how he got
Yes.
injuries.
All right, so 1st of April. So it would be that would have been after the strategy, the cross-examination of the strategy.
My Lord, I actually have a note that accused number 2 called the attorney to give instructions. This was just before the adjournment. Injuries shown on the elbows correspond with pulling of the arms for 4+ hours. I would have expected it to be lower on the arms. That was the answer. Then pressure of the rod on the posterior side of the knees. Then we adjourned at 12:40 to 13:30. And then the cross-examination continued. And this is where the version is put. But my Lord,
I have, my note says, after it was put to him, it starts with not showing the doctor the handcuff marks, and the handcuffs were on, it was pulled, period of 4 hours, and then it was put to him, before the alleged assault, the accused had no injuries. The answer to that was no comment. Are we on the same place?
we are.
Okay. My note says the following. The injury sustained was not because he fell off a bakkie. My note does not say police vehicle.
Then, my Lord, I will leave that. My apologies.
Because that's how I
definitely have it as
recalled
police
it.
van, but
And I actually found my note. It's on my book 3, page 105. It was the 166th question put to the witness.
then I will leave it. Thank you, my Lord.
Thank
How
you.
do you know, sir, that Miss Smith ran up the stairs because she heard screams.
Meneer, hoe weet u dat juffrou Smith het op die trappies bestyg omdat sy geskree gehoor het?
Ik weet niet waarvan.
Ek weet nie daarvan nie.
Ik weet niet waarvan.
I don't know. I'm not aware of that.
That was put to the witness, and I can find it.
My Lord, it wasn't long after, it was on the 2nd of April, in the morning part thereof, Ms. Mkabai's cross-examination, and it says, my note reads, co-accused heard screams. She ran up the stairs to inquire who is screaming.
Well, was it to Captain Lombard? Was it Brigadier Nana? Because
It's Brigadier Hanana.
Yeah.
It's Brigadier Hanana, my Lord. It's on the 2nd of April.
no,
It's put to Brigadier Hanana.
because I remember that came with Brigadier Nana because, and the context was that Brigadier Nana said he was at FCS
Yes,
and accused number 3 was at FCS.
yes,
He told us he never heard anything.
yes.
Then it was put to him. And I'm reading from my notes, page 126, book 3. It was the 6th and 7th and 8th statements to the witness. It was about the screams. And then he said he did not hear any screams. And he gave a longer explanation. Then it was put to him that Miss Smith, accused number 3, was not far from where he was. And in that context, it was then put to him.
Indeed.
Accused number 3 heard the screams and ran up to inquire.
Who is screaming?
And his answer to that question was, he bears no knowledge.
Indeed, my Lord.
Good, so you may continue on that.
Thank you, my Lord. So, you heard what the Honourable Court has just said, sir?
Het gebeur wat die agbare of so pas gesê het, meneer.
Correct, my lord.
So, how do you know that Miss Smith ran up the stairs to inquire about the screams that she heard?
Hoe weet u dat juffrou Smith die trappe opgeharoep het om navraag te gaan maak aangaande die geskreeëry wat sy gehoor het?
Because is she correct?
I am not certain.
No, I don't understand that answer.
Nou verstaan ek nie daardie antwoord nie.
Van, ik heb ik was maar net één keer gezien.
Because I saw Miss Smith once. Only once I saw Miss Smith.
Wait, listen.
Maybe you should, one should explain how it works. So Mr. Van Rijn, you must listen carefully. You see, Miss Mkabai was not there at Sea Border that evening. You agree?
Correct, my lord.
The only way she will know what happened there is if you tell her, because you're the client that gives her the instructions. Right?
Correct, my lord.
Now, it was told to Brigadier Nana that during that night, accused number 3 heard the screams and went upstairs, or wanted to go upstairs. Not upstairs, but to see border. It's higher up. It could be up steps, but do you understand?
Verstaan my lord.
I understand, my lord.
So the inference is that you're the only one that could have told Mrs. Mkabai that. Right?
Die inference is nou die afleiding, né? Inference, die afleiding wat iemand kan maak. Net u kon vir juffrou Kabai daarvan ingelig het, want juffrou Kabai was nie by daardie perseel tydens daardie gebeure nie, né? Die inference beteken dit is nou die afleiding wat een kan maak.
Are you following?
Dis korrek, my lord.
Now, the prosecutor wants to know, how did Ms. Nkabai come to know of that? Because it could only be you that have told her that.
Kan nie meer nou nie, my lord.
I can no longer remember, my lord.
But if you didn't hear the screams, why would you have told her that?
Nou, indien nie hier
Do you understand?
Hoeso u vir haar dan nou dit vertel het as dit nie gebeur het nie, verstaan nie?
Korrek, my lord.
You can continue if you want to clarify further.
My lord, I think I will abide by the decision, by the last answer. We will argue the matter. Thank you, my lord.
Yes.
So, who begged you to become a state witness?
Meneer, wie het vir u gesmeek om 'n stadsgetuie te word?
When would that have happened?
Wanneer sou dit gebeur het?
Toe my Mamasbury was ek op besoek. Die mense ek ken nie wel nie.
When I was at Malmesbury, 2 persons paid me. 2 unknown persons paid me a visit.
Who are they?
Maar gevra om te, ek moet wel iets gee, kan ek vrykom?
And they asked me, can I give them something, then I'll be freed?
Who are these people?
Ek
Are
ken nie die
they?
mense.
I do not know these people.
Is it Captain Lombard
Is dit kaptein Lombard?
Nee,
No.
or anyone from his team?
Enige ander persoon van sy span?
ek ken nie wel nie.
I do not know them.
Because I have to put it to you, sir, and that was also Brigadier Nana's testimony.
Want ek moet dit aan u stel, meneer, want dit was ook Brigadier Anana se getuienis,
That was never on the cards.
want dit was nooit op die kaarte nie.
That never was part of the strategy.
Nooit was dit deel van
Die strategie nie.
die strategie nie, ja.
Dis wat gebeur.
Dat dit is what happened.
I put it to you that that is not the truth.
Ek stel dit aan u, meneer, dit is nie die waarheid nie.
Your testimony is that Malima
U getuienis is soos volg: Malima
was assaulted in the presence of her 2 young children.
is aangeraan in die teenwoordigheid van haar 2 kinders.
Dis korrek, my lord.
How do you know that?
Hoe weet u daarvan?
Ek het daar kinders gesien, ja.
I saw children
In the boardroom.
in die raadsaal.
Dis korrek, my lord.
Both children.
Beide kinders.
Ek het kinders gesien, ja.
I saw children, yes.
Were you just saying ek het 'n kinders gesien?
Ek het kinders gesien.
I saw children.
The evidence of Captain Lombard and Brigadier Nana was
Kaptein Lombard, sowel as Brigadier Anana se getuienis,
that the husband, Makalima's husband,
is
and
dat Malima se man
and her 2 children were made comfortable in the office of the forensic social worker and the FCS offices.
en haar kinders, haar eggenoot en haar kinders is gerieflik gemaak in die kantoor van die maatskaplike dienste langs aan. Daar is hulle tuis gemaak.
And in fact, Brigadier Nana takes it further and says the
Verder getuig Brigadier Anana en sê
girl fell asleep But the boy was up and down all the time, entertaining the police
Die
officers.
meisietjie het aan die slaap geraak en die seentjie het haar op en af gehardloop daar en die polisie vermaak.
And he had him specifically in his eye all the time.
En hy het nog spesifiek hierdie seentjie in sig gehad. Deurentyd het hierdie seentjie in sig gehad, in sy sig gehad.
How is it possible that you say that they were in the boardroom?
Hoe is dit moontlik dat u nou sal sê dat hulle was in 'n raadsaal?
Maar hulle was daar.
But they were there.
So I put it to you that that also is not the truth.
Meneer, ek stel dit aan u dat dit ook nie die waarheid is nie.
As die waarheid.
It's the truth.
And it's also highly improbable
That is
that
ook-
would happen the way you explain.
Hoogs onwaarskynlik dat dit so gebeur het soos wat u dit verklaar.
Thank you, my lord. Yesterday,
Gister
you told us that it is so that Sergeant Johnson did.
But I'm going to try not to adjourn. You may proceed.
Thank you, my lord. Eh, Yesterday you indicated that indeed Sergeant Johnson did explain your rights to you and hand you that SAP 14A at 4 o'clock on the 5th of March there in the vehicle.
aangeduig, gister en getuig. Gister het hy getuig. En aangedui die dat Susan Johnson in der waarheid u regte aan u verduidelik het en vir u die 14A oorhandig het. Dit is was nog met die datums.
5de Maart,
Die
4 uur die
5de Maart,
oggend.
die 5de Maart, 4 uur die môre. Of die oggend.
Correct?
Regsom. Correct, my lord.
Okay. Why was your instructions to Miss Mkabai that Sergeant Johnson never approached you? You were asleep. She never explained your rights to you.
Hoekom het u vir juffrou Mkabai gesê dat sy het nooit vir Sergeant Johnson gesê nie?
That the statement is that Sergeant Johnson never approached him
Yes.
to explain his rights. That's at the car.
Sergeant Johnson het nooit vir u genader en vir u regte verduidelik nie. En het geslaap.
Yes.
Is correct, my lord.
Correct, my lord.
Nee, ek verstaan nie. What is correct?
I don't understand what is correct. What
Ek
is,
kon nou net sy met die blyle gee.
I remember she gave me the page.
Okay, let me just try to explain again.
Kom ek probeer laat ek dit weer verduidelik aan u.
That was Sergeant Johnson's testimony.
Dit was Sergeant Johnson se getuienis.
Okay? She said she completed that SAP
Sy het
14A.
gesê dat sy die 14A voltooi.
She came to you in the car where you were sitting upright.
Sy het u na u toe gekom in die kar waar u gesit het, reg opgesit het.
She explained your rights to you. She handed you your copy.
Sy het aan u regte verduidelik en sy het vir u afskrif gegee.
Okay?
Want ek kan nou nie.
Not that I can remember.
Okay, you need to choose which one.
U moet meneer, u moet nou besluit nou watter een.
Because Ms. Mkabai put to Sergeant Johnson your instructions.
Want juffrou Mkabai het aan Sergeant Johnson u instruksies gestel
That at 4 a.m. that morning,
dat 4 uur die betrokke oggend, om 4 uur die betrokke oggend,
you were sleeping
u het geslaap.
You were never approached by her,
Hy is nooit deur haar gaan nader nie.
and she never explained your rights to you.
En sy het nooit die grondwetlike regte aan u voorgehou nie.
Dis korrek, wat ek kan onthou, ja.
That's correct, I can remember that, yes.
What is correct? That she did not approach you and did not explain it to you.
Wat is
Sy
hy?
niks van my wat duidelik het, hè.
Oh, nothing was explained to me by her.
Okay.
Just one moment. Can you recall what happened with Colonel Clark?
Dis korrek, my lord.
Now you'll recall that on the video, he took out the book with the pink pages.
Dis korrek, my lord.
And then you took out a piece of paper,
Dis korrek, my lord.
which you then showed him.
Dis korrek, my lord.
So she did give it to you, and you knew what it was because you told him on the video. Can you recall that?
Onthou u dit?
Ja, my lord.
You will recall that when he testified, I made mention of the number of the form that you had in your possession. Can you recall that? When Colonel Clark stood there where you're sitting now.
Korrek, my lord.
Because Colonel Clark also wrote the number of that document on your forms. Can you recall when he testified here? He stood there one morning. He was the only person that stood in the witness dock.
Die een oggend wat hy hier gestaan en getuig het, hy is al getuie wat verkies het om staande te getuig.
Dis korrek, my lord.
Carry on.
Thank you, my lord. So, the question is simple.
Daarvoor die vraag is eenvoudig.
Why did you instruct Ms. Mkabai to say that never happened?
Hoekom het u vir juffrou Kabaai gesê dat dit nooit gebeur nie?
In other words, Sergeant Johnson never approached you?
Met ander woorde, Susan Johnson het nooit vir u genader nie.
She never explained your rights to you?
Sy het nooit u regte aan u voorgehou nie.
That never happened.
Dit het nooit gebeur nie.
Hallo, ek weet ek het die blye gekry.
All I know that I received the page.
En dat sy niks aan my wat duidelik het nie. Ek is seker as sy die blye aan my gegee het.
Nothing was explained to me by her. I'm not even certain whether or not the page was given to me by her.
When you saw Colonel Clark and that document, you had your own one. You took it out and you gave it to him.
Toe ek in kolonel Clark sien op daardie beeldmateriaal, het die eie blaai gehad en het self uitgehaal en dit aan hom getoon, meneer.
Dis korrek, my lord.
Korrek, eerlik.
So I'm simply going to put it to you.
Ek gaan nou tot eenvoudig dit stel.
Those instructions that you gave to Ms. Kabai was not the truth.
Daardie instruksies wat hy aan juffrou Kabaai gegee het, was nie die waarheid nie, meneer.
Was die waarheid.
It's the truth.
Okay. Were you ever at any stage in footcuffs or shackles?
Was u ooit op enige stadium voet geboei?
Nee.
You talk
I'm speaking about this case. I'm
At that
speaking
time.
very specifically. The 6th, the 4th, and the 5th of March.
Ek verwys spesifiek na hierdie saak. Die 4de en die 5de Maart spesifiek hierdie saak.
5th of March last year.
Yes.
Vir die jaar.
Net aan my hande was boeie.
Hands were handcuffed. Only my hands were handcuffed.
Leg irons. In this year, on one of those dates, when we went for the inspection.
Oh, yes. Thank you, my lord. I'm indebted to you.
I'm going to take a short adjournment. I asked for some water to be brought to me, but I think they're heating it up, so it's going to go out and in. 2-3 minutes.
All right.
Thank you, Mr. Van Renstel, and the oath.
Van Rens nog steeds ter eet, meneer?
I suspect that either there's dust on my books here. So it started when I moved the books. I've been told by my registrar that there was a lot of dust here this morning. We're not going to do anything about it today. I'm going to push through. But maybe just if they can ensure that Tuesday morning before we start, if they can just ensure that this place where I'm sitting, we must try and get it dust free, because that's what normally brings on this condition. So and for this place to be cleaned. How long will it take? I'm going to take an adjournment for a quarter of an hour. If they can just dust this area.
As the court
Court will
pleases.
adjourn.
All rise.
was nee.
Dis korrek, my lord.
So that includes when you were taken to Colonel Clark for the confession.
Insluitende die tyd toe u na kolonel Clark toe geneem het vir daardie bekentenis.
You were not wearing footcuffs,
U was
correct?
nie aan voetboeie nie.
Korrek, my lord.
Okay. Why was that put to Colonel Clark as one of the reasons why you had difficulty to walk?
Hoekom is dit aan kolonel Clark gestel en dit as die rede gegee hoekom u ongemaklik loop?
Ek weet nie.
I do not know.
That must be your instructions to Miss Mkabai.
U moes dit vir juffrou Kabai gesê het. Dit moes die instruksies aan juffrou Kabai gewees het.
So did you go a photo, ma?
Perhaps she made a mistake.
Thank you, my lord. If my learned colleague can remember correctly, on that day, I even asked the video to be shown whether my client was having shackles or not, because I was not sure. I only saw the hand as if the hand was going towards the legs of my client. It was clarified that that hand was going to unlock the handcuffs, not the shackles. That was corrected on that day, my lord.
Can you recall when that evidence was laid?
When I was cross-examining Kenneth Clark, my lord.
I
When Colonel Clark testified, the video was played, Miss Mkabai cross-examined, and she specifically put, he says he was struggling to walk due to the following factors. 1, he was in pain during the torture and including his private parts were pinched. 2, he was beaten on his knees. 3, he was beaten on top of his feet. And 4, he had, and this is how it was put, handcuffs on the ankles.
handcuffs and ankles.
Yeah, my lord.
It was the 7th statement put to Colonel Clark. It appears on page 159. These numbers are my own numbers, so sometimes I combine things. It's book 3. Objection is overruled. You may proceed.
Thank you, my lord. As the court pleases. Mr. Van Rijn, can you please explain why you gave those instructions to Ms. Mkabai that you were wearing footcuffs?
Meneer Van Rijn, kan u asseblief verduidelik hoekom u vir juffrou Kabai gesê dat u was in voetboeie gewees?
Ek weet wel wat duidelik ek was in voetboeie nie.
That's not what I said.
So that's something that Ms. Mkabai took out of her own.
So dit is iets wat sy daar eie uitgesê het.
Is that what you're saying?
So did you go a photo, ma?
She must have made a mistake.
Sure. Why did you not correct her when she made that mistake?
Hoekom het u nie vir haar reg gehelp toe sy daardie fout begaan nie?
Soos ek al was daar en dit sê dat ek maar
Give.
Jammer, ek het nie gehoor nie.
soos ek was daar en dit sê dat ek maar
Oh, as I understand, she rectified it.
No, she did not, sir.
Nee,
No,
sy
you don't
het
have
nie
you
meer.
don't have to argue with the accused. Mr. Van Rijn has answered the way he answered.
Thank
You
you,
can
my lord.
argue the point. Yes.
How did you sustain bruises to your back?
Hoe het u hierdie skafmerke op die reg opgedoen?
Sibore, ek weet nie hoe nie.
It's Siboda, I do not know how.
Maar met was slattery.
What with the beating?
The beating, where you were beaten from the sides, slapped,
Ja, is dit die beating toe u geklap gewees het?
or
Kan
the,
nie presies sê nie.
I cannot say exactly.
or the beating when you were hanging, according to your version?
Or die slanery soos u gehang het op u weergawe.
Kan nie presies sê nie.
I cannot say exactly.
Yeah. It also, and I'm just putting this to you and this will be argued, it doesn't make sense to us either. It was put to Dr. Zimri that you had bruises to your back.
Dit maak nie sin tog wanneer ons betoog sal ons daar oor betoog. Dit is aan Dr. Zimri gestel dat u hierdie skafmerke op u rug opgedoen.
Correct, my lord.
But none of your explanations indicates how you would have obtained those.
Tog geen van u verdedigings kan
was it-
aanlei aan hoe u daar aangekom het nie.
Was it a bruising? You were not here.
Excuse me, my lord?
You were not here, Ms. Swanepoel, when Dr. Zimri testified.
No, I wasn't, my
It
lord.
wasn't it wasn't a bruising. It was not a bruising. And it was not put to Dr. Zimri by the defense that it was a bruising. And why I remember it, it was an abrasion,
Oh, yes, that's right.
not a bruise. And it was healing.
Yes,
And the debate was about the age
yes.
of the abrasion. So similarly, you are challenging Mr. Van Ryn on things that were put incorrectly to
My
state
apologies.
witnesses.
Lord.
What's good for the goose is good for the gander. If the defense must be precise, the state must be precise. I don't want wrong facts to be put to a witness, whether it's an accused or whether it's a state witness. Please. Thank you.
Apologies, my lord. So if I understand you correctly, you, on the morning of the 5th, on your version, you slept in a vehicle outside, correct?
Daarvoor, indien ek weergawe reg verstaan, dat die oggend van die 5de het die buitekant in die voertuig geslaap.
Correct, my lord.
On your version, when you were when you were taken to Makalima's house,
Op u weergawe toe u na Malima se huis toe geneem is,
you also my question is, did you also sleep there for the duration of the 3 hours approximately that you were sitting in the vehicle outside?
my vraag aan u is dit ook nou vir die ongeveer 3 uur het u in die voertuig geslaap daar buitekant?
Ek het 'n bietjie skynsel in kar, ja.
Yes.
Just lay down
And
on the
then
side.
it is so that after the failed confession to Colonel Clark,
Dit is ook so dat na die mislukte bekentenis aan kolonel Clark,
you were taken to St. Helena Bay police cells.
is Sint Helena Bay se aanhoudingscelle toegeneem,
Correct, my lord.
Where you ate, you took your medication,
dat die geëet, dat die medikasie ingeneem.
and my question is,
My vraag aan u is volg,
did you then also sleep there?
het u dan daar ook geslaap?
Daar was nie tyd om te slaap.
There was no time to sleep.
So we are now at Idem that on the 5th of March, after the failed confession
Ons
attempt
is
to
nog
Colonel
met
Clark,
eens dat op die 5de Maart, na die mislukte bekentenis voor kolonel Clark,
you were indeed taken to St. Helena Bay, as Sergeant Johnson testified.
U is inderdaad St. Helena Bay toe gaan neem soos per Sergeant Johnson se getuienis.
Correct, my lord.
Can you explain why it was put to Sergeant Johnson that you were only detained at St. Helena Bay on the 6th of March?
Kan u asseblief verduidelik hoekom is dit aan Sergeant Johnson gestel dat u slegs op die 6de Maart by St. Helena Bay aangehou is?
My lord, those were not my instructions. My instructions were that my client was taken to St. Helena Bay after the confession on the 5th of March. 5th of March, my lord.
Okay, let me check it. Date that she testified. This one. That's in Bovana.
The 2nd of April, my lord.
You know,
And my lord, it was in the context where Sergeant Johnson said my client was taken to Sardana Bay on the 5th. I disputed that. I said on the 5th of March, my client was never taken to Sardana Bay police station. He was taken to St. Helena Bay. Thank you, my lord.
March.
Objection is overruled. My notes, book 3, page 143, 16th paragraph.
As the court pleases, my
It's in
lord.
line with what the prosecutor puts. If I speak loudly, it's because I'm aware that I have a mask on my face. So I don't know how it comes over.
It is a little muffled, my lord. I'm spitzing my oor to hear, but I'm trying my very
But
best.
we'll have to live with it. Instead of us losing time,
Yes.
where I have an irritation in my throat or an allergic reaction, let me just check with the stenographer whether the record can pick me up. I'm not concerned about anything else. As long as you can hear me, as long as the court record can pick it up, then I'm happy. Television stations, etc., I'm not concerned about.
She's indicating that it's all in order, my
Thank you.
lord. Thank you very much. So, Mr. van der Rijn, can you please explain why that was your instructions, that you were detained at St. Helena Bay only on the 6th of March?
No, my is verduidelik was die instructies dat is tussen die Helena Bay en die 6de aangehou.
Correct, my lord.
Correct, my lord.
In fact, you were already detained on the 5th of March.
Inderdaad, is al reeds die 5de Maart daar aangehou.
Maar ek weet ek is hoofdtoewan St. Helena Bay.
Yes, but I know I was taken to court.
No.
from St. Helena Bay.
Let there be no misunderstanding. It was put to Sergeant Johnson that you were detained at St. Helena Bay from the 6th of March. Now you telling us that you were there on the 5th, you confirm that you were there on the 5th. Right? Did you tell your attorney, but I only went there on the 6th?
seker nie, maar weet ek was op St. Helena by, sal ek is.
I'm not sure, but I know I was in St. Helena by cells.
You've made the point.
Thank you, my lord.
But Exhibit GG. The one that is incorrect.
Oh, yes.
That's where the 6th of March in St. Helena Bay comes from.
My lord, the
Exhibit GG, the corrupted document.
yes. My lord, may I be allowed?
I know the question was asked, but that's where it comes from. Because that register reflects that he was taken to St. Helena Bay on the 6th. Remember that column where the dates were filled in
Yes.
afterwards?
Yes. Indeed, my lord. May I please be allowed to put something to the witness just to get his comment? I understand that that wasn't deduced as evidence during this trial within a trial, but may I be allowed to put to the witness that the St. Helena Bay cell register as well as occurrence book does in fact confirm that he was booked in on the 5th of March?
No, but he confirmed it already.
Yes. Thank you, my
Remember yesterday he said
Yeah.
that he went to St. Helena, some questions from the court, and then he took his medication and he had something to eat. I'm not going to comment on the sleeping because the evidence now is different as yesterday.
Yes.
Yeah, but carry on. I hope you're going to get to a point sometime and get to the contents.
Yes, I am, my lord. Just one last aspect, and this is with regards to this taking of you to Makalina's house,
Nog laaste aspek, meneer, u gaan neem na Malima se woning toe
and that you were traveling in Sergeant Fortuyn's vehicle
en
for
dat
that
is
trip.
in Fortuyn se voertuig gedrewe.
No.
Not Fortuyn, Johnson. My apologies. My apologies. Johnson's vehicle, Sergeant Johnson.
No, you see, Mr. Apollo says he was in Fortuyn's vehicle.
Yes.
He was with
Sergeant
in a
Johnson.
vehicle where
Yes,
Sergeant Johnson was. Didn't
Next
say it was Sergeant Johnson's vehicle. I thought you had the whole night to prepare your issues. Carry on.
Thank
I
you,
should
my
have
lord.
kept you
I'm-
here yesterday
I'm-
afternoon and we would have been finished. Yes.
I merely wanted to put it to you that that was never put to Sergeant Johnson when she testified.
Al wat ek aan u probeer oordra is dat dit is nooit aan Susan Johnson oorgedra het in sy getuienisaflegging nie.
Did you give those instructions to Ms. Mkabai?
Meneer, was dit die instructies aan mevrou Mkabayi daar?
Is seker nie.
I am not certain, my lord.
All right. Then with regards to...
Just one moment. Did I hear you correctly? That you're not sure?
Ja, my lord.
Carry on.
Thank you, my lord. It was specifically put to Sergeant Fortuyn
Dit is spesifiek aan Susan Fortuyn oorgedra
that you were taken to Makalima's house
is na Malima se huis toe geneem
in this white polo,
in die wit polo
and that Makalima was then brought to you,
en dan Malima is toe na u toe gebring
and you were asked to identify whether this is
Malima is.
Dis korrek, my lord.
Correct, my lord.
Whilst yesterday when you testified about this, you are now no longer sure whether she was brought to you or whether it was a photo that was shown to you.
Tog
Correct, my lord.
Correct, my lord.
So what created this uncertainty?
Hoekom nou hierdie onsekerheid, meneer?
Want ek is nie seker nie.
Because I'm not sure.
No. You see, when it was put to Sergeant Fortuin, there was no uncertainty. It was always that she was brought to you, the body. Do you understand?
Verstaan my Lord?
So yesterday, now you're unsure whether it was a photograph or the body. Are you with me?
Verstaan my Lord?
Now Ms. Swanepoel wants to know what created the uncertainty. Why are you now almost sure of what happened? But a few weeks ago, you were still very sure. That was when Sergeant Fontaine testified. In fact, it was a week and a half ago. What caused you to be uncertain?
Wat veroorsaak nou hierdie onsekerheid, meneer, want 2 weke gelede is dit met alle sekerheid aan Fortuin oorgedra dat Malima na die voertuig toe gebring is. Gister verander dit. Hoekom nou hierdie onsekerheid, meneer?
Ek is nie
Wat
seker nie.
veroorsaak hierdie onsekerheid? I'm not sure.
Is it because Mr. Apollos told us about the photograph?
Is dit daarom dat meneer Apollos vir die hof gesê het, die melding van hierdie foto's gegee?
That caused your uncertainty?
Wat dan tot hierdie, wat aanleiding tot hierdie onsekerheid gelei het?
Ja, my Lord.
Nou,
Ja,
my
my
lord.
Lord.
Nou, my lord.
Once again, I'm going to put it to you, sir, that you are adapting, amending your evidence, trying to fit in with that which your co-accused, Mr. Apollos, testified.
Weer eens, meneer, stel ek dan u dat u pas u getuienis soos u aangaan, u wysig u getuienis soos u aangaan, u probeer om u getuienis aan dit wat u medebeskuldigde Apollos oorgetuig het te verweef.
Similar to what
Soortgelyks,
Mr. Apollos did when he testified.
net soos wat meneer Apollos gedoen het ten tye van sy getuienisaflegging.
Do you want to comment?
Wat is die kommentaar daarop?
As jy waar nie.
That is not the truth.
Okay. And now I am at the confession document.
Ek handel nou
Exhibit
met
JJ.
die bekentenis dokument.
Now, firstly, I want to put it to you, sir,
Eerstens wil ek dan u meneer stel
that when you arrived there in the office with Captain Siekwe,
toe u daar by die kantoor aankom en met kaptein Seekoe,
you were the one who told him, I was here this morning. And
u is een wat vir hom gesê het ek was die oggend hier.
And then that man said that my handcuffs must be off.
En daai man het gesê dat my handboeie moet verwyder word.
So you asked for him that your handcuffs must be removed.
U is een wat vir hom gevra het dat hulle u handboeie moet verwyder.
Ja, my Lord.
Nou, my lord,
Are you saying that's not so?
sê u dit is nie die geval nie, meneer.
Jy kan nou nie.
Nou dat I can remember,
I want to put it to you, sir, that at the timestamp 2:15 of video 1, that's exactly what happened.
ek wil dat u stel, meneer, dat dit die tydstempel 2:15 die oggend, dis wat gebeur het.
No.
No, 2:15 on video 1.
O, 2:15 op video 1.
The timestamp on the video, so it's from the time the video started running, it will be 2 minutes and 15 seconds. So just so that there's no confusion, because now it becomes 2:15 in the morning. That's what I heard. But I knew what you meant. I knew what you meant. But Mr. Yankees didn't know because you were not precise.
My apologies, my lord. I meant to say the video and on the first file at the time of 2:15. 2 minutes and 15 seconds.
It's all in one exhibit, but the exhibit has two components, and it's labeled Stevino MOV1, Stevino MOV2.
Indeed, my lord. So, sir, I want to put it to you, that is not the sign of a person who is scared and nervous. You come in there and you tell the officer, this morning my cuffs was removed, I want them removed.
Meneer, nou wil ek dan u stel dat daardie optrede, dit is nie 'n optrede van 'n man wat bang is daar, wat bedreig voel daar, want u het uitgesê, meneer, ek was vanoggend hier gewees, hierdie handboeie was verwyder, ek vra dat dit weer eens verwyder moet word. Daardie optrede is nie 'n optrede van 'n bang man nie.
Wat ek kan onthou is dat hy het gevra dat die boeie moet losgemaak word.
All I can remember, he asked that the handcuffs must be removed.
After that was your request.
Na u versoek, meneer. Dit is na u versoek, meneer.
Wat ek kan onthou nie.
Not that I can remember.
Furthermore, sir,
Verder, meneer,
the time 03:34,
die tyd 03:34,
you identify those documents.
identifiseer daardie dokumente.
In other words, the form of this exhibit JJ.
Met ander woorde, hierdie vorm, hierdie bewysstuk,
Because you tell him,
want u sê vir hom,
ek het al vanoggend die papiere gedoen, meneer.
I already have done these documents this morning, sir. Or
To
this
which-
morning I did this document, sir.
To which he replies, ja, maar ons gaan dit nou weer doen.
Waarop hy antwoord en sê dat ja, ons gaan dit weer eens doen.
Dis korrek, my lord.
Correct, my lord.
So I put it to you, sir, that is a sign of a person who is well aware of his surroundings. You come in there, you see this document and you tell him, I've already done this morning.
Daarvoor, ek stel dit aan u meneer, daardie optrede is 'n optrede van 'n persoon wat wel bekend is met sy omgewing. Dit is 'n persoon wat weet wat rondom hom aangaan. Want daar sê u meneer, ek was vanoggend hier gewees. Ons het deels met hierdie vorm gehandel.
Ja, is korrek.
That is not correct.
Okay. Furthermore, I want to put it to you, sir, that throughout the duration of this interview, and
Verder, meneer, wil ek dan u stel dat derentyd tydens die duur van hierdie onderhoud
I put it to you
stel ek dit aan u meneer
that you were very comfortable. You had your arms rested on the table in
dat
front
u
of
was
you.
baie gerieflik meneer. U het die arms op die tafel gerus meneer.
You stretched out, arms wide stretched out above your head.
Wyd opgerek meneer.
You even bend your back.
Selfs agteroor gebuig.
All rise.
If you want to re-examine on it, you can do that, but counsel can't answer for the witness. I was watching the interpreter as he was explaining, and you didn't raise an objection. You rather gave me your view on the answer, so the prosecutor can proceed. Are you going to get to the contents
Thank
at
you,
some
my lord.
stage?
I am, my lord. I am. Thank you, my lord.
Remember, we're just dealing this inquiry is about the admissibility of the statement.
Indeed, my lord.
That's all we have to deal with. You don't have to go in for the kill to try and destroy his credibility more than what you've already challenged.
As the court pleases, my lord.
Yes.
I want to put it to you, sir,
Meneer, ek kan bestel, meneer.
that everything, contrary to what your testimony was yesterday,
In teenstelling aan dit wat jy gister oorgetuig het,
everything in the
At all in my office for the last 20 minutes. There's something here. I believe it's dust. And I can hear the aircons are on now. It weren't on earlier. I'm just going to step outside to a tiled area. And I'm going to come back in. I don't want people to leave. Court will adjourn.
All rise.
Meneer, wat is die kommentaar daarop?
No comment.
I've got no comment, my lord.
So now when we get to the meat of this document,
Nou, wanneer so nou die kern van hierdie dokument bereik,
and I'm referring to page 16, 17, and then the questions and answers.
Does Mr. Yankees have a copy with him? Does Mr. Yankees have a copy with him? Thank you. Mr. Van Rijn, leave it with Mr. Yankees first. And we'll go there when we need to.
los het maar meneer Jantjies, meneer van Rijn.
Yes, thank you.
Thank you, my lord. So I'm going to refer to first the statement itself, page 16 and 17, and then the questions on page 20 and
Ek
21.
verwys eers na die verklaring self, bladsy 16 en 17, en dan die vrae en antwoorde.
Okay. So when this starts off, and this is the second file of the video, the time at 00:28.
En dan dit is nou die begin en is eerste leer van die video, die tyd.
00:28. So it's 28 seconds in.
In 28 seconds, my lord. 28 seconds in.
28 secondes.
Then Captain Sekwe explains to you.
Kaptein Seep verduidelik aan u.
Okay, ons gaan nou jou verklaring begin.
Goed. We're going to start with your statement now.
Jy gaan vir my vertel wat gebeur het.
You are going to tell me as to what had happened.
Just one moment. Mr. Yankees, the English is the record. So the prosecutor's reading, because the exhibit is in Afrikaans. So you can't whisper. Remember, you're also competing now with the aircon. So the English must come out loud enough.
Yes, my lord.
When we do it the other way around, of course, then it's acceptable to use the Afrikaans slightly at a lower
Yes, my lord.
level. But for now, when she's reading in Afrikaans, just ensure that we get the English out loud enough.
Yes, my lord.
Thank you.
Thank you, my lord. May I then, for the sake of Mr. Yankees, just repeat that? So, okay, ons gaan nou jou verklaring begin.
Okay, we're going to start with your statement now.
Jy gaan vir my vertel wat gebeur het.
You are going to tell me what had happened.
Alles. Dan gaan ek dit neerskryf.
Then I will write it down.
Verstaan jy?
Do you understand it?
Maar onthou,
But remember,
ek het vir jou gesê,
I told you,
jy het die reg om te swyg.
you got the right to remain silent.
So voor ons nou begin,
Therefore, before we start,
wil ek net weer seker maak
I would like to make certain again,
dat as jy 'n prokureur teenwoordig wil hê,
if you want an attorney present,
alvorens ons die verklaring maak,
even before we start with the statement,
verstaan jy?
do you understand it?
And the answer is,
En-
nee, dis reg meneer, okay.
And the antwoord is, yes, it's right, sir. Okay.
Just one moment. Do you hear what the prosecutor says?
Hoor jy wat die stadsadvokaat sê, meneer?
Correct, my lord.
Correct, my lord.
No, I just need to explain to you before I'm going to ask you to answer. What she's reading now does not appear on this form, but it's on the video. So she's reading from what was said on the video where you and Captain Siaku Kui were sitting. Are you with me?
Ja, my lord.
Now, do you confirm that that's what happened there that morning?
Correct, my lord.
Good. Thank you.
Thank you, my lord. Captain Sekwe's explanation continues.
Kaptein Seeko se verduideliking duur voort.
Jy moet vir my stap vir stap vertel
Step by step, you must tell me
wat jy my wil vertel.
what you would like to tell me.
Okay.
Okay?
En dan sê sy ja meneer.
And the answer, yes, sir.
Correct, my lord.
So jy moet my geleentheid gee om dit te skryf.
You must give me an opportunity to write it down.
En dan sê sy ja meneer.
And the answer, yes, sir.
So ek gaan gou luister wat jy sê.
Therefore, I'm going to quickly listen to what you're telling me.
Jy kan maar begin.
You can start.
Okay.
Just a moment. Just give Mr. Van Rijn the opportunity to confirm. Do you confirm that, Mr. Van Rijn?
Bevestig jy dit wat jy nog gehoor het?
Correct, my lord.
Now, when the video was played here in court, on the big screen, the audio was not that clear. But when one plays it on different devices, as the advocates, both defense and state, would have played it on their laptops, I now played it on an iPad and on a laptop. Then one can hear the audio much better. That's why I'm asking you whether you confirm that what she's reading now from what she could hear, whether that's correct. You with me?
Staan, my lord.
I understand, my lord.
Thank you.
Now, I'm going to stop here
Nou gaan ek hier stil staan.
and I'm going to go back to your testimony yesterday.
Dan keer ek terug na u getuienis gister.
You said,
Dit is u getuienis
and that was also what was put
en dit is ook wat gestel gewees het
to the witnesses,
aan die staatsgetuies
that what is contained in this document
bevattend in hierdie dokument
does not come from you,
kom nie van u af nie.
it comes from the police.
Dit is die polisie self se maak.
What was put to the witnesses was the police, overall police, not in identifying any person.
Aan die getuies gestel gewees het. Dit is die polisie sonder om enige spesifieke individu uit te ken nie of na te verwys nie.
But yesterday your testimony was,
Tog gister u getuienis is soos volg.
this is Fortuyn's story.
Dit is hierdie is Fortuyn se weergawe.
Okay?
My
Yes,
lord,
Mr. Kabai.
those were not my instructions. Sergeant 14 story, it's about my client sustaining injuries over the weekend by falling from a friend's buggy. That is the part that I said it was Sergeant 14's story.
No. A prosecutor is not referring to your instructions. When you put it to the witnesses, you didn't identify a particular police officer. You said the police generally. There we're still on the same page, right? Or the two of you might be on the same page. You might have heard wrong. Because what she said yesterday, when the accused is now in the stand, you left it open because he couldn't identify on your cross-examination who it was. But yesterday he attributed this to Fortuyn whilst in the witness stand.
As the court pleases, my lord.
Thank you. That's how I understood the question.
Yes, indeed.
That's also how I understood the evidence.
Thank you, my lord.
That is why I said to you earlier, why are we going on for so long?
As the court
But
pleases,
okay,
my lord.
let me hear what he says. Did you follow the debate now, Mr.
Het
Van
die
Rijn?
gesprek gevolg nou, meneer?
Nou my lord.
Nee, edele.
So I'll simplify it for you. So remember when Ms. Nkabai cross-examined the police, I'm just saying the police generally, she put it to them that this story that you were told to tell the officer came from the police, because those were your instructions, right?
Correct my lord.
But she never identified an individual. She didn't say it was Mr. Lombard or Brigadier Nana or Mr. Fortuyn. You understand that?
Verstaan my lord.
I understand, my lord.
Now the prosecutor says to you, why suddenly now yesterday you told us, but this, what you've told Captain Siekwe is actually Fortuyn's story.
Ek het gesê is Fortuyn hulle.
I said it's Fortuyn and them, my lord.
Fortuyn and them.
Fortuyn and them,
hulle.
my lord.
I see.
I'm going to shorten this.
Meneer, ek
But
gaan
I-
hierdie verkort.
I want you to please, sir, and concentrate and tell us what exactly was the story that you were told by Fortuyn or Fortuyn and them to tell Captain Siekwe.
Meneer, ek wil hy moet asseblief mooi luister en vir die hof sê wat is hierdie storie wat u vir Fortuyn en them moet gesê het.
Dat ek het Sam Jekon die kind na Malima toegevat
That myself and Jacqueline took the child to Malima,
en dat Kelly wou hom stuur.
that Kelly sent him,
En dat ek die next dag na Malima toe gegaan het.
that the following day I went to Malima
Glo my kat. Van my kat.
for my portion.
Dis wat ek nou.
That's what I remember.
That's why I'm asking you now,
Dit is hoekom ek vir u vra, meneer.
and I'm giving you a second opportunity.
Ek
Please
gaan vir u 'n tweede kans, meneer.
think clearly
Dink mooi
so that you tell us everything
sodat u kan vir hierdie agbare hof alles vertel
that you were told to say.
wat u voorgesê het om te sê.
I didn't hear an answer.
Wat is die antwoord, meneer?
En Kelly wat gepraat het van die man met die rooi t-shirt.
And Kelly who spoke about the man with the red t-shirt.
What precise, what exactly did Kelly say?
What exactly did Kelly say?
Dat 'n man wat Joshlin met 'n rooi t-shirt gevat het.
That a man with a red t-shirt took Joshlin.
Dis wat ek nou.
That's what I can remember.
Nothing else.
Next other thing.
Wat ek kan nou nie.
Not that I can remember, my lord.
And you're saying that this all came from the police.
En u sê dit alles en alles kom van die polisie af.
Korrek my lord.
Correct, my lord?
Did they tell you what your cut was going to be?
Het hulle vir u gesê wat is die porsie? Wat sou die porsie gewees het?
Wat ek kan nou nie.
I cannot remember.
Surely that's something very important.
Sekerlik, dit is iets baie belangrik.
Would you not have remembered that?
Sou u nie dit onthou het nie?
Maar ja, net as dat ek next dag sal gegaan het van my kat.
I was told that I would have gone the following day for my portion.
Dis al.
That's all.
That's all.
Dit is al.
Seker.
Korrek.
I understood your testimony to be
Hoe
yesterday.
ek u getuienis gister verstaan het.
The story about the microwave,
Hierdie weergawe rondom die mikrogolfoond,
that came from you.
dit is u eie weergawe.
Dis wat gebeur.
That is what happened.
Okay. Anything else that came from you except the microwave issue?
Enige iets anders wat van u uitgekom het behalwe u mikrogolf vraagstuk?
Nee, my lord.
No, my lord.
And you are sure about this?
Is u seker daarvan, meneer?
Wat ek kan onthou.
I can remember.
Okay.
Yes.
My apologies, my lord. I don't want to go through everything. I'm just trying to find the...
Are you going to put your version to the witness?
Okay. All right. So,
Meneer,
I put it to you
ek stel dit aan u
that, in fact, everything in this document
dat inderwaarheid alles en alles bevattend in hierdie dokument
came from you.
is u werk, is u ander werk.
Dis die waarheid.
If
Not true.
if one considers the way in which you go into intricate details, how you explain this to Captain Sekwe and answer his questions.
En aangenome hoe u die intrieke details aan Kaptein Sekwe oordra.
Can I just interrupt you, Ms. Swanepoel? I just forgot to clarify when the state advocate had just asked you about the contents.
Die staatsadvokaat het sopas van u gevra oor die inhoud.
So you, when you were sitting with Captain Sekwe, you knew what to tell him,
Die tyd toe u met
if I understand you correctly.
indien ek u getuienis reg verstaan, voor Kaptein Sekwe of in Kaptein Sekwe se teenwoordigheid, u het geweet wat u is besig om vir hom te vertel. U het geweet wat vertel u vir hom.
Ja, man, ek was gesê wat ek wil vertel.
Yes, because I was told what to tell him, my lord.
So you had the ability to remember the detail of what you were told the previous evening.
Daarvoor u het die vermoë gehad om te onthou wat aan u voorgesê gewees het.
Korrek, my lord.
Korrek, edele?
And you ensured on the last question, the portion about the cut, that you mentioned that.
En is seker van die laaste vraag, die porsie gedeelte wat u sopas melding van gemaak het.
Korrek, my lord.
Korrek, edele?
Now, with no reference to your condition, I must still decide that. In
Ek het
layman's
nog nie-
terms, they would have said you were wide awake. in layman's terms.
Onthou ek kan sê ek was baie wakker geweest. Ek het nog nie beslis oor u bekentenis nie. Ek moet nog daaroor beslis.
Not so?
Correct, my lord.
Right, so now we've covered the other issue as well.
As the court pleases, my lord. As the court pleases. So may I then just specifically deal with the questions?
Ek gaan nou spesifiek met die vraag handel,
And the contentious issue, of course.
die betwiste vraagstukke natuurlik.
And that is the first question.
Die eerste vraagplatsy.
I'm sorry. Het jy weer vir Kelly gesien na dit? Ja, meneer. That's
Did
on
you
page
see-
20.
Did you see Kelly after that? Yes sir, that's op bladsy 20.
And it goes over to page 21, leading
Dit
to the
slaat
next
oor na
question.
bladsy 21 toe.
And in fact, sir,
Inderwaarheid meneer,
the time is 14 minutes and 30 seconds into the video.
dit is 14 minute 30 sekondes in
That's
die
video 2. That's video 2.
Indeed, my lord, that's video 2.
Video 2.
Captain Sekwe asks you, het jy weer vir Kelly gesien?
Kaptein Sekwe vra vir u, het u weer vir Kaptein Sekwe ask you to see Kelly again
Na julle vir Joshlin gelos het daar,
after you left Joshlin there,
al is dit die volgende dag.
even if it's the following day.
And your answer is, ja meneer, net die volgende dag.
En die antwoord daarop is yes sir, only the following day.
And at the time, 14 minutes 50 seconds.
In die tyd 14 minute 50 sekondes.
Het jy vir haar enigiets gevra?
Did you ask her anything?
Your answer is, sy het vir my gevra meneer.
The answer to that is she asked me, sir.
As ek nie 'n man gesien het met 'n rooi T-shirt nie,
If I did not see a man with a red T-shirt,
'n man met 'n rooi T-shirt
a man with a red T-shirt
het glo vir Joshlin gevat, meneer.
ostensibly took Joshlin, sir.
Maar sy weet, sy het vir Boeta gestuur met Joshlin na Malima toe.
But she knows she sent Buddha with Joshlin to Malima.
Dis wat hom my was gesê was om dit te sê.
That was what was told to me to say.
What you said was, Kelly spoke of a man with a red T-shirt,
Wat jy gesê het dat Kelly het van 'n man met 'n rooi T-shirt gepraat het.
dat die man met die rooi T-shirt vir Joshlin gevat het.
Dat the man with the red T-shirt is the one who took Joshlin.
But you actually, in answer to this question, say, she actually asked you about this man with the red T-shirt.
Tog in die antwoord daarop, sy het eintlik vir u gevra oor hierdie man met die rooi T-hemp. Dit is sy wat vir u gevra het met hierdie man met die rooi T-hemp.
And whether you hadn't seen him.
Of u nie vir hom gesien het nie.
Dit was so wat verduidelik aan my.
That was what was explained to me.
That was not what you told the court now when I asked you.
Dit is nie wat u vir die agbare hof gesê het toe ek vir u gevra het nie.
Maar dis wat hulle vir my gesê het.
But that was what was told to me.
And this little add-on,
En hierdie klein byvoegingkie.
maar sy weet, sy het vir Boeta gestuur met Joshlin na Malima toe.
But she knows she sent Buddha with Joshlin to Malima.
Where did that come from?
Waarvan kom daarin?
Van die polisie af.
From the police, my lord.
I put it to you, sir,
Ek stel dit aan u meneer.
that is not the truth.
Dit is nie die waarheid nie.
Dis die waarheid.
It's the truth.
Okay. At 21:45,
Om 21:45.
so 21 minutes and 45 seconds into the video.
21 minute 45 secondes in die video.
Captain Sekwe sê,
Kaptein Sekwe says,
"Right ou, okay. Ek gaan nie die vrae vir jou lees nie.
good, I'm not going to read the questions to you.
Ons het dit dan nou net saam gedoen.
We've just done it together now.
Jy's tevrede
Are you satisfied
dat alles wat ek geskryf het
that everything that I written down
korrek is?"
is correct?
And the answer is ja, meneer.
And your answer to that, yes, sir.
And then Captain Sekwe says, "Meneer, kyk vir my."
And then Mr. Sekwe said that, sir, look at me.
To which you reply, "Ja, meneer."
And your answer to that, yes, sir.
And then at 22 minutes into that video,
Om 22 minute.
oh, sorry, let me just give you an opportunity to reply.
Jammer meneer, kom ek geen vir jou kans om daarop te reageer.
Is that correct what I just read to you?
Is dit reg sover? Dit het net sopas aan u voorgelees het, is dit reg sover?
Korrek, my lord.
Korrek, my lord.
That's how it happened?
Is dit hoe dit gebeur het?
Ja, ek het my samewerking gegee.
Yes, I lended my cooperation, my lord. I lent, given, yeah,
Then-
gave.
Then at 22 minutes into that video,
22 minutes in hierdie video.
this is when you now add, which you say you had forgotten.
Dit is nou die tyd toe u nou byvoeg dit wat u sê u vergeet het.
Daai wat ek weer na Miss Malima op my eie
That which I went to Miss Malima out of my own accord.
Miss Malima, ek het voor die kind se besigheid
Before this child's business,
het ek en sy gesels
me and her had a discussion.
en sy het vir my gesê
She told me
ek moet my CV bring vir haar.
I must bring my CV to her.
Dan sal sy vir my kyk as sy vir my by haar man vir werk kan kry.
And she'll see whether or not she can organize a job. Yeah,
My lord,
Yes.
is that also part of the confession?
I'm sorry?
The part my learned colleague is just reading now, is it part of the confession?
It's
If we
part of the exhibit. It's part of the video.
Part of the video.
Yep.
Thank you, my lord.
As I've indicated at the time, that one had to go and listen to the audio. After I've made a ruling in the matter, depending on which way I find, I might issue directions as to how the record be constructed, because all of that's in Afrikaans.
Yes.
And it's on the video itself. So there's no transcript
Yes.
in the record for easy read, because if you don't have a VLC player, I don't know how people still work with CDs and stuff. But in any event, that's what it is. Then you can't really play it. So you have to download a VLC player first,
Yes.
and then you can play it.
My lord, may I add at this stage, I have done the exercise.
Let's cross that bridge, because
Yes.
if I don't admit
Yes, of course.
the statement, then we don't have to go there.
Of course, my lord. I
So
was-
you will know this afternoon, before we leave here, whether you need to do the extra work or not.
Thank you, my lord.
Remember, I said I'm going to hear argument, everything today.
Yes, my lord.
I'm in no rush to go home.
I'm almost finished.
Yes.
I promise. I promise. So, where does this come from?
Meneer, waar komt die vandaan af?
Die CV storie.
De CV?
Yes.
Ja, meneer.
Dat sy hom heel vooruit, dat er heel as hy my heel vooruit,
Dat-
my
dat-
CV bring hom my.
That she asked me, that is correct, yes, you requested me to bring my CV to her.
Isn't it actually you that asked her, can I not bring my CV to you? And
Is
you
it-
can find out for a job for me?
Is dit die andersom, meneer? Is dit die wat vir haar gevra het of u nie u CV na haar toe kan bring sodat sy vir kan werk kan kry?
Dis wat sy vir my gesê het.
She's the one that told me.
Yes, at her husband.
Ja, by haar man.
Dis korrek, ja.
Correct,
Yes.
Edele?
So my question is, where does this come from? Because this is now your add-on, the portion
Yeah.
that you almost forgot.
Ja, maar nou my vraag aan u, waar kom die hier vandaan? Want dit is u eie byvoeging daarin. Dit is die gedeelte wat u byna vergeet het. Waar kom dit vandaan af?
So laat die tyd toe ons by Malima huis kom toe kry hulle ook my CV daar.
No, just, I don't think you understand.
Ek dink nie dat u die vraag verstaan of hierdie stelling of vraag verstaan nie,
So
meneer.
I'm going to simplify it,
Ek gaan dit vir u vereenvoudig, meneer.
because I don't know why council always have to make things so difficult. I'm going to take you a step back
Ek gaan vir u stapgewys neem, meneer,
of what you've told us in your evidence in chief.
wat u vir hierdie agbare hof gesê het en u getuienis in hoof, meneer.
You said you added on the portion of the cut because you knew you were told to say that. Right?
Korrek, my lord.
And the only thing in this content that doesn't come from the police is the story about the microwave. Am I right?
Die enigste gedeelte in hierdie inhoud wat nie vanaf die polisie kom nie, is die storie van die mikrogolfoond. Regsop.
Korrek, my lord.
Now I'm going to divert a little bit because
Nou gaan ek 'n bietjie afwyk.
I want to explain the context to you.
Ek wil aan u die inhoud verduidelik.
You were here and you were laughing
U was hier sittend en u het gelag
when I gave Captain Siekui a hard time for not writing everything.
toe ek vir kaptein Seekoei haar tyd gegee het die dat sy nie alles neergeskryf het nie.
Can you remember?
Onthou u dit nog?
Korrek, my lord.
Yes, my lord.
Because I was giving him a hard time.
Want ek het vir hom haar tyd gegee.
Can you remember that?
Onthou u dit?
Korrek, my lord.
And you and Miss Smith were having a good time whilst I was doing that.
En u en juffrou Smit was gesellig daar, sittend gesellig,
Because I can see you.
want ek kan sien van waar ek sit.
As you're smiling at me now.
Daar glimlag sy daar.
Can you remember?
Onthou u dit?
You were in a good mood,
U was in 'n goeie bui, meneer.
right?
Korrek, my lord.
Because he didn't write down everything.
Want hy het nie alles neergeskryf nie.
In fact, what I observed from you was almost like a celebratory mood
En der waarheid,
because I was nailing the policeman.
toe my oë op u geval het, dit het gelyk asof u besig is met 'n feesvieringie daar, want ek is besig met hierdie beampte, ek gee hierdie beampte haar tyd.
Can you remember that?
Onthou u dit?
No, my lord.
I remember it, my lord.
Now, but you said a lot more than what he wrote down.
U het nou meer gesê as wat u nou sê.
Right?
Reg so?
Verstaan, my lord.
I understand, my lord.
And this thing about the CV and that has got nothing to do with the story of the police.
En hierdie dingetje nou oor die CV het niks te doen met die storie met die polisie nie.
Right?
Reg so?
Correct, my lord.
Correct, my lord.
Now Ms. Swanepoel says to you, now explain this to us. Tell us. You say the add-on, where I started, was simply because he was scared, because he had to comply. Now, how does the CV story then now come in?
No,
It's got
no.
nothing to do with the police.
Want dit is u getuienis, meneer, dat u moes nou die polisie se opdrag gehoorsaamig het. Nou waar kom hierdie storie nou van die CV vandaan af? Want dit het niks te doen met dit wat die polisie vir u voorgesê het om te sê nie.
Do you have a comment?
Maar wat is die kommentaar daarop?
No comment.
No comment, my lord.
Can I just take you to another issue whilst I
Kom,
have your attention?
ek neem vir u aan 'n nog 'n vraagstuk terwyl ons daarmee besig is, meneer.
You've now told, you've confirmed with Ms. Swanepoel
U het nou sopas met mevrou Swanepoel bevestig
that all of this that you and Captain Sekui discussed on the video,
Dat
that
dit-
happened.
dat dit alles en alles wat u met kaptein Sekui op die beeldmateriaal bespreek het, inderwaar het dit gebeur of inderdaad het dit geskied.
Right?
U het dit bevestig? Reg?
Correct, my lord.
Korrek, edele?
And were you always aware of it? That the devil is in that detail? To quote Ms. Harriman?
Ten alle tye bewus gewees van die video.
That there's hidden stuff on the CD that's not on the printed document or the handwritten document that's handed up in the court.
Dit was ten alle tye dat daar was van die goed wat neergeskryf het wat die bevatting is aan hierdie dokument wat in die hof en handig is nie.
Nee, my lord.
Nou, my lord.
You heard me on Tuesday
U het vir my Dinsdag gehoor
when I said I looked at the videos again.
toe ek gesê het ek het op my eie het
On
ek
Monday.
weer die beeldmateriaal gaan besigtig.
Correct, my lord.
Korrek, edele?
Thank you, my lord.
Dankie, edele.
This explanation continues. It's not only the CV.
Hierdie verduideliking duur voort. Dit eindig nie net by die CV nie.
You also say,
U het ook gesê
sy koop alles, meneer.
she buys everything, sir.
Enige iets wat jy het, koop sy in.
Anything
Verstaan,
that-
meneer?
Anything that you have, she buys, sir. Do you understand, sir?
So, sy sou nou vir my, hoe kan ek nou sê, gewoonlik 'n customer.
She would, how can I put it now? She is usually I'm usually her customer, yeah. I'm usually, yeah. One can say I'm a customer.
Ek sou net, toe was ek laas by haar gewees, meneer, want ek verstaan dan nou, die kind is weg.
I would then, when I was by her, sir, now I understand that the child is gone.
En ek en Boeta het haar dan daar laaste gelos.
And myself and Buddha left her there. That was where we left her.
En Kelly het dan gesê, ons moet haar daar gaan los.
And Kelly said, we must leave her there. We must go and leave her there.
Now that's the portion where it seems as if you get very irritated on the video. And can you remember telling him that?
Onthou jy dat die vir hom dit so gesê het, meneer?
Correct, my lord, maar dit is waarheid
Correct, my lord, but it's not the truth, my lord.
van my af.
That is not it doesn't originate from me, my lord.
Meneer, ek wil I want to put it to you.
Sir, I want to put it to you.
It's clear that you are emphasizing the fact
Dit is duidelik, u lê klem op die feit
that this is how it happened.
Dat-
And Kelly sent you in Boeta.
dit is hoe dit gebeur het dat Kelly het vir u en Boeta wel gestuur.
As correct,
That is not correct, my lord.
Captain Sekwe then gets a little annoyed with you and he says, ek het dan vir jou gevra, meneer, maar okay.
Kaptein Sekwe raak toe 'n bietjie geïrriteerd met u of die hele squad met u want hy sê want I just told you, sir.
At 23 minutes into the video, you say,
23 minute in die video sê
nee, you say,
hy sê jammer,
daai was my kat,
that was my portion
wat ek gaan soek het daarso by hulle meneer.
which I went to look for from them, sir.
And Captain Sekwe asks,
And then Captain Sekwe asked,
kat vir wat?
a portion for what?
And you answer vir Joshlin se vermisting.
And then you answer by saying that for Joshlin's disappearance or vanishing.
ja, dat is correct.
No, that is not correct.
No, but is the prosecutor correct? That's what the discussion between you and Captain Sekwe.
Maar wat die stadadvokaat by u wil weet, meneer, dit wat sy sopas aan u oorgedra het, was dit die gesprek tussen u en kaptein Sekwe?
Nie van die verdwijning van nie van die geld wat sal kry oor die verdwijning van Joshlin.
Not about the money that I would have gotten for the disappearance of Joshlin, my lord.
Because that was not part of the story that either Captain Fontaine, Sergeant Fontaine or Sergeant Fontaine hulle told you to say.
Want daardie gedeelte, dit is die deel van die gedeelte wat kaptein Fortuin en hulle vir u voorgesit het om te sê nie.
Am I right? Because that's how I understood the evidence.
Is dit die agbare hof korrek? Want dit is hoe die agbare hof daardie getuienis verstaan.
Dis seker nie, my lord.
I am not sure, my lord.
Did Fontaine them tell you that you would have received a cut from Malima?
Het Fortuin hulle vir u gesê dat u sou nou u porsie of u kat by Malima sou gekry het? U moet sê,
Correct, my lord.
korrek edele?
Carry.
And I did ask you, I'm asking you again.
Ek het vir u vroeër gevra, weer eens gaan ek vir u vra.
Fortuin did not say what your cut would be.
Fortuin het nie gesê wat is hierdie porsie wat vir u toekom nie.
Ja, my
In
lord.
all fairness, Fortuin of anyone else.
En alle regverdigheid Fortuin en niemand anders nie.
Nee, my lord.
No, my lord.
Because at 23 minutes and 10 seconds,
Want om 23:10 sekondes
you say,
sê u
ek soek R5,000 daar by Malima.
I want a 5,000 rand from Malima.
Dis is seker nie.
I am not certain.
Waarvan, what are you not certain about?
Wat is dit waarvan u seker is nie, meneer?
Van die 5,000 rand.
About the 5,000 rand?
Did you mention that figure, 5,000 rand, to Captain
Het die
Sekwe,
daardie bedrag
on the video?
daardie bedrag op die beeldmateriaal, het die melding gemaak van daardie bedrag op die video. Dit is 'n gesprek op die video.
Kan wees, my lord.
Possible, my lord?
Kan wees, my lord.
Can be, my lord?
And where would that have come from, sir?
En nou waar vandaan kom daar, meneer? Waar sou dit vandaan gekom het, sir?
Bedrag 5000 kom miskien van my af.
Yes, yeah, according to me, from me.
Is that because that would have been the cut that you would receive
Is dit
for
dalk
this?
dalk so dat die gedeelte of die porsie wat u so ontvang het vir hierdie?
Nee, my lord.
Nou, my lord,
Because if I remember correctly,
want indien ek reg onthou,
in Boeta's in Mr. Apollos' confession,
in meneer Apollos se bekentenis,
he says
sê hy,
he did not know how much he was going to receive because you and Kelly had spoken. Kelly had only spoken to you about the money.
hy wat Apollos is, het nie geweet hoeveel hy so gekry het nie, want net u en Kelly het 'n gesprek gehad, net u en Kelly het oor die geld gesels.
As jy waar,
Not true?
Maybe in fairness to Mr. Van Rijn, is your brain still functioning? Because I saw you yawn, I heard the other day.
Oh, no, that wasn't a yawn. So my apologies, my lord. I really was not yawning. No.
So, if you listened the other day, Mr. Van Rijn,
Meneer Van Rijn, indien u nou die dag geluister het,
when it was yesterday morning,
dit was gisteroggend,
was it the day before? No, it was the day before. Tuesday and Friday.
ja, Dinsdag en Vrydag,
The questions to Mr. Apollos was read out.
die vraag aan meneer Apollos is hart uitgelees.
And there was a question that says, hoeveel sou jy van die 20,000 rand kry?
There was a question as to the effect, how much from the 20,000 would you have gotten?
Remember, this is now a question posed to Mr. Apollos.
Onthou nou, dit is 'n vraag aan meneer Apollos, né? Let daarop, dit is 'n vraag na meneer Apollos.
And he answered,
En sy antwoord daarop was soos volg:
Kelly het nog niks vir my gesê hoe gaan die geld cut werk nie. And he uses the word cut.
Kelly has not told me as to how the portion, I'm going to use the word cut,
Sy het net
It's gonna
saam
be dealt with.
Stefano gepraat.
she has just spoken to Stefano so far.
So this is the background where the question is now put to you
Dit is
about the 5,000.
Dit is op daardie agtergrond gegrond. Die stelling deur die stadsadvokaat is gegrond op daardie agtergrond.
Do you understand that?
Verstaan u, meneer?
Verstaan, my lord.
I understand, my lord.
Would you like to comment?
Wat is die kommentaar daarop, meneer?
Oor die 5000.
Oor die 5000 rand?
About what I've just put to you, sir, and what the court has just explained.
Because you told me it's possible that you could have mentioned the number, the 5,000 rand.
Ja, want dit was nog net genoem nou oor die 5000 rand, net die kommentaar op dit wat u hof aan u vereenvoudig het, sowel as dit wat ek u vroeër aan u oorgedra het, meneer. Wat is die kommentaar daarop?
Jy kan maklik opraat dit van 5000.
Herhaal asseblief.
Jy kan maklik opraat dit van 5000.
I could have easily made mention of the 5,000 rand.
The question is, where would you get that amount from?
Die vraag bly staan, waar sou u hierdie bedrag gekry het, meneer? By wie sou u hierdie bedrag ontvang het, meneer?
By Malima.
From Malima?
Are you now saying that Malima told you that you would get 5,000 rand?
Sê u nou dat dit is Malima wat vir u gesê het u sou 5000 rand ontvang het?
Ja.
Nou,
Okay, then I don't understand.
nou verstaan ek nie vir u nie, meneer.
Polisie.
Die polisie, wat van die polisie?
Dan sê ek het 5000 rand kry.
Nee, sê dalk het 5,000 rand.
The police told you that you
Ek
would
het
get
geld
5,000 rand.
kry met die.
I'll receive, yeah. The police told me I'll receive money.
And the 5,000 rand is something that only you knew. and told Captain Siakwe.
En die R5,000 is net u was daarvan bewus gewees het en u vir Susan Siakwe daarvan vertel.
No. I don't know whether I heard right. The 5,000 rand, who mentioned that amount the first time? Was it the police?
Ek meneer,
Me, my lord,
Did they tell you that you will get money? The police?
ja my lord,
And did they tell you how much you will get?
ja my lord,
no, my lord.
Mr. Van Ryn,
Meneer Van Ryn,
I would like to put it to you
ek wil graag dit aan u stel,
that the contents of this document
dat die inhoud van hierdie dokument,
came from you and only you.
dit is u is die outeur van hierdie dokument en net u bly die outeur van hierdie dokument.
And you were well aware of every word that you told Captain Siakwe.
En u was baie bewus van elke woord wat u vir kaptein Fortuin
Siakwe?
Siakwe vertel het, dankie.
ja my lord.
Nou edele,
Thank you, my lord. I have no further questions.
Thank you. Ms. Mkabai, re-examination.
dankie u edele,
Mr. Van Ryn,
meneer Van Ryn,
I want you to take us back to the sea border officers.
ek wil graag hê u moet vir ons terugneem na die seegrenskantoore toe, meneer,
Especially at the time when you were hanging.
veral die tyd toe u gehang het.
Do you understand?
Verstaan u?
Sorry my lord,
Korrek, my lord.
Do you still remember
Onthou u nog
the color of the chairs you were hanging?
die
On?
stoele waarop u gehang het? Onthou u nog die kleur van daardie stoele?
Is this re-examination?
Yes, this is real.
On what basis?
On the basis that he was asked to do demonstrations with these chairs.
No, but the color of the chairs was never raised. This is new evidence. It's not admissible under re-examination. Question, is this allowed?
Mr. Van Ryn,
Meneer Van Ryn,
can you give before this court
kan u asseblief vir die agbare hof
a description
'n beskrywing gee
of the chairs that you were hanging on at the sea border offices?
van die stoele waarop u gehang het tegen seegrense kantore?
He gave a description yesterday, and it's on record. Do you have any
Hy
re-examination
het gister 'n
in
beskrywing gegee
respect of
daarvan
that point?
en is op rekord. Het enige ander ondervraging, hy het wel gister die beskrywing van hy stoele gegee.
Were the chairs
Die stoele
you were hanging on
waarop u gehang het,
at sea border
die
offices
seegrense kantore,
same as the chairs that you pointed here in court?
is hulle dieselfde as die
Question,
stoele
is
wat
this
u in die hof
allowed?
het?
The evidence is clear from this witness that they're not. The only similarity was the height, because he said it was similar to the chair, seeing that I have to explain the evidence now. That he was sitting on when he conversed with Captain Siakwe, and it had that soft back. Ms. Nkabai, I'm going to take a short adjournment. I don't want us to have a misunderstanding. I'm not going to allow new evidence. I'm not going to allow evidence to be repeated. I will allow re-examination. And re-examination is merely to clarify. So no new evidence, no repetitions. We've had it earlier on in this trial, where we would go back and forth. All I have to determine in the trial within a trial relates to the admissibility of the statements. and the basis upon which it was attacked was laid, and the evidence has been laid. I'm going to take, it's now 11:10. I'm going to give you 10 minutes. Then I'm going to come back. Take a 10-minute break, or do you want 15? 10 enough? I'm going to take a 10-minute break, and then we will do the re-examination, and we will thereafter, are you going to call any other witnesses on the trial, Ms. Makabai? Because
Yes, I will do, my lord.
yes, where's the witness?
The witness is in Saldanha. When I'm done, he's going to be called immediately.
No, can you get the witness available at the court, please?
I'll do that, my lord.
So that we can deal with the witness at the moment you're done. Remember, I had asked parties in the week to ensure that everybody's here. I'm not going to adjourn, so you must make arrangements that the witness come here the moment you're done. Once we're done with Mr. Van Rijn, I will go on with the next witness, and we will sit today until we're done. Court will adjourn.
All rise.
Council came to see me in chambers, and therefore I said we can delay slightly longer. Mr. Van Ryn, you still under oath?
Meneer Van Ryn is nog steeds onder eed om die waarheid te praat, meneer.
Thank you, Mr. Kabay.
Thank you, my lord. Mr. Van Ryn, yesterday, under cross-examination,
Meneer Van Ryn gister onder kruisondervraging
you were given a crash.
is Sakiri gegee daai die kerk is aan u oorhandig.
Korrek.
Korrek?
Is the size of that crash similar to the size of the crash you were hanging in?
Die kerk se grootte of lengte is dit soortgelyks aan die een waarop u gehang het? Selfde grootte?
Ja, maar
Of
silwer
lengte?
een is man om weer dieselfde grootte, ja.
More or less the same size, however a silver one.
The last part?
Silver in color.
Okay. When you say more or less the same size, which one is longer, which one is shorter?
Hier sê dan nou min of meer dieselfde grootte of lengte, wat die een is korter, wat die een is langer.
Ek weet nie as jy die silwer een dieselfde is soos die blou een van gister nie.
I'm not sure whether or not the silver one is the same as the blue one from yesterday.
When you entered the offices for the taking of the statement,
Toe u die kantore betree vir die bekoming van daardie verklaring,
you testify that you were in pain.
dit is die getuienis dat u onder pyn gewees het.
Korrek, my lord.
And when we watch the video, we've seen you when you entered the room that you were in pain.
En wanneer 'n mens na die beeldmateriaal kyk, merk een op dat u is onder pyn.
Is that correct?
Korrek, my lord.
The question is disallowed, although it was answered because it's not re-examination.
Thank you, my lord. Mr.
Dankie,
Van Ryn,
edele meneer Van Ryn.
while you were taking your statement, were you comfortable? While Captain Sikwi was taking your statement,
The question is disallowed, it's not re-examination.
Hierdie vraag word nie
And the
toegelaat
question
nie.
was asked in cross-examination and the witness answered.
Dit is nie hier ondervraging nie. Hierdie vraag is vroeër aan kruisondervraging gevra en hierdie getuie daarop geantwoord. Derhalwe word hierdie vraag
with due
afgeskiet.
respect before this honorable court, I have a right of re-examination on cross-examination.
Yes. Yes, you have.
And this was put on cross-examination. Hence, I'm re-examining him on it.
I've made an order, the question was disallowed, and I gave the reasons.
Ek het beslis en hierdie vraag word afgeskiet en ek het die redes daarvoor gegee.
I have no questions for
Thank you. Thank you, Mr. Van Ryn. You may go back.
Dankie meneer Van Ryn. Keer terug na u
You may call the witness.
beskuldige bank toe.
my lord.
You may call the witness.
I cannot call the witness.
Mhm.
The witness was present in court yesterday. Today, I am advised by the officer that the witness is sick. The witness has a gum and it was extracted.
Was the witness subpoenaed, or did you take up my offer of ensuring that the witness is present? Otherwise, I could have authorized a warrant for the witness if the witness didn't appear, or I could have secured the witness's presence. I made that request a few times, including yesterday.
My lord, I didn't foresee the need of that because the witness was available. On last two occasions, he was available in court.
Well, there was an attempt in chambers to present evidence to me, and I refused to engage counsel on that in chambers, where Both of the prosecutors, yourself and Mr. Harmse, attended. That was part of the delay. Now, and I indicated that I will not entertain issues in chambers, and if you want to present evidence as to why the witness is not here, feel free. Because you brought a witness to me, one of the police officers. And I said, well, you feel free to call him. Let him tell me about this witness.
My Lord, I didn't bring the officer to chambers for him to give evidence. I brought him for him to explain to court the predicament I am in.
The point is, Ms. Nkabai, this is a public court. I engage with counsel in chambers on issues, and we don't deal with evidence in chambers. You would have seen that I was irritated because I was presented now with a person who wants to give me information, and he started talking. He's sitting there, the warrant officer. And then I said, well, whatever he wants to tell me, let him take the stand. I'll swear him in, and he can say it to me on record. Are you going to call the witness, yes or no?
My Lord, I leave this in the hands of the court. I
I'm sorry?
apologize for bringing the officer in chambers. As far as calling him as a witness, I'm leaving this in the hands of the court, my Lord.
I can't hear you.
I'm leaving that in the hands of the court.
No, it's your choice.
I'm not calling him as a witness, my
Thank
Lord.
you. Is that in the case for accused number 2?
Yes, my Lord.
Thank you. Right. I told the parties in the week of how I'm going to deal with the argument. I will give you 5 minutes without interrupting you. All three of you. Thereafter, I may interrupt you. Yes, Ms. Herman, it's unheard of that I'll give you 5 minutes. I would normally take you on from the first minute.
I'm ready, my Lord.
But we've indicated 45 minutes. Jerry, will you run the clock for me, please? I'm going to tell you when to start. And I want to make it clear that we're dealing only with the admissibility of these statements, which ruling is an interlocutory ruling. Admissibility is provisional because it can be revisited at the end of the trial. But also, we've been engaged in this exercise. There's not much law involved here, it's facts. That's what this is about. Because the law is clear, the law is straight. So you can address me on your case and the facts and the inferences. I got to the 45 minutes, and that's actually longer than what I think the parties need. Is because I know I will interrupt you. So I'm giving myself 15 minutes to delay you. So I was working on 30 and the 15. So once we start, we're going to start with you, Ms. Ehrman. And supposing we start at 11:45, it's now 11:39. Your clock will run for 45 minutes. Your clock will run for 45 minutes. And that will take us to 12:30. Then if you want to, Mr. Harmse, we can take a 5-minute break or so, just to move the chairs. Then we can proceed with Mr. Harmse. And then these 45 will run. And then we'll take another short break of 5 minutes. So that will take us to 1:15, 1:20. Right? If you want to take a lunch break then. Feel free to ask me. I'm now going to ask the accused how they feel about it. And then we can deal with Ms. Nkabai's argument. 45 minutes will run. That will take us till after 2. And then I will give you a 10-minute reply for the state. And that's it. If I am in a position after argument without taking an adjournment, I will give an order right there and then. If I need to just reflect on some of the issues that's been raised, I will take a short adjournment and I will come in and I'll give the order this afternoon still before we leave. Now, what we could do, it's two things, Mr. Apollos, Mr. Van Ryn, Ms. Smith. We can push through on those short breaks and then you can eat afterwards. I don't know what you get for lunch. I've never seen what you get for lunch. All I know, I think it's provided by the local police station. And the reason I know that is because they actually print the forms on Mrs. Naidu Chetty's printer. So they asked her earlier on to make copies. So you can guide us how you feel after Mr. Harmse. If you feel you want a longer break so that you can have your bite, if you feel you're going to take a quick bite in those 5-10 minutes in between and then eat your food afterwards, you can let me know then. Now, the reason why I treat you differently on lunch as anybody else, because you are in custody. It's not as easy to get access in the morning to have something to eat before you come to court. You at the mercy of our situation here, but you're entitled, and it's only proper that you don't sit there and you're hungry. Do you understand that, Mr. Apollos? Understand that, Mr. Van Ryn? So when we take that short break after the prosecutor, you can discuss. And then when you come back, you can tell us what you want to do. Reason why I don't want to take a long break is, and yes, I'm taking time by explaining, but we're still before the 45. Is that all of you know tomorrow is Good Friday, it's a long weekend. Most of the people in this courtroom, I'm talking about the court staff, including myself, but count me out, have to travel on this R27 back to Cape Town. It can be a nightmare on the day before a long weekend. Mr. Apollos and Mr. Smith has to go all the way to Malmesbury. And it's also a treacherous road. So if I can rather let people leave earlier and we sacrifice our lunchtime, then I'm prepared to do that. But each one has their own needs. So the parties can inform me. Council has any particular arrangements after we've taken the first break, you can tell me what your choices are. Thank you, Ms. Ehrman. Ms. Naidu Chetty will run the clock. Your time will run out at 12:30. Don't ask me for indulgences.
My Lord, I actually think I'm going to be shorter than that time, but I definitely will not be going till 12:30. I'm limiting my arguments to certain things. My Lord, it is trite that whenever the admissibility of evidence is challenged on the basis that an accused person's rights has been violated, a trial within a trial must be held. This court acting with extreme caution. At that certain point when we reached Captain Lombard's evidence, made that decision, and we went into the trial within a trial. Now, the state bears the onus of proof. That is trite law, the S versus Zuma 1995-2, SA 642cc bears reference.
Unlike what the legal expert, is it African? What is that? African News Network?
I believe so, my lord.
That's the news I watched on the weekend,
Indeed.
where they had an expert saying the onus rests on the defense.
My lord, this is a learned court, an experienced court. By no means am I in any way undermining the court, but I have made copies of that particular judgment should the court require one.
Can I just interrupt you? The authorities, any authorities, remember it's an interlocutory finding. So we're going to revisit the issue in all probability again at the end of the case.
Indeed.
In the event that I'm with you. If I'm against you, it's end of the story. So hold back on your authorities. If needs be, when we deal with the main argument, if it gets there, you can give me the authorities.
Noted, my lord.
I already said my ruling today will be on the facts, period. It's either one way or the other.
Certainly, my lord.
Yeah.
So, essentially, this Constitutional Court decision declared Section 2171B unconstitutional. End of story. All parties ad idem, state bears the onus. The other case I wish to draw the court's attention to, my lord, is that of S versus Latta and another 1994 1 SACR 447 Appellate Division. In this matter, this honorable court acted correctly when it found that whenever an accused person disavows the contents of a statement made, that this court must have sight of that document. So the prosecution, therefore, is entitled to cross-examine, which is exactly what has transpired in this instance. So on both those authorities, this court acted cautiously and correctly on the law. The applicable sections, my lord, is Section 217, 219, trite, freely and voluntarily, sound and sober, without undue influence. The state's position is that it has discharged that onus when it led evidence of Captain Lombard and Sergeant Fortuin. Those witnesses' evidence were not shaken under cross-examination. They made credible witnesses. In fact, the honesty of Sergeant Fortuin must be noted when he was referred to the warning statement, my lord. And the court will recall he made reference to scuff marks that will only surface after 24 hours, which the doctors didn't note on the J88. So the honesty of that witness cannot be disregarded. The more important part of the state's evidence, my lord, was the independent evidence of the doctors. And it was the doctors' evidence that the allegations, as I put to them and demonstrated to them, was highly improbable. In fact, their evidence was that they would have expected to see fractures, far more severe injuries, as opposed to what they saw.
I know your 5 minutes is not up, but may I interrupt you on this score?
Certainly.
Because I'm expecting argument coming from the cross-examination that the doctor's examination fell short of an acceptable standard.
I disagree with that, my lord. Remember what Dr. Zimri's evidence was. It's patient-based information. So when a person reports to them, they report what is wrong, and therefore the doctors look for that. Now, I will go one step further. If these accused presented the way they say they were assaulted, there is no way either of those doctors would have not noted the extent of those injuries. They didn't present that way. They didn't present that way on their videos either. So the doctors went. No fault can be placed at the feet of the doctors because, like they said, it's patient-based. It's what the patient tells them is wrong. But I even went one step further. Even if it wasn't told, even if the doctors were not told, their observations, there's no way these doctors would not have noted the observations had they been visible. My lord, as far as the issue of credibility is concerned, I know this court is not going to pronounce on the credibility of accused 1 and 2.
That's one of the reasons why in these type of inquiries the court doesn't give reasons.
Yes. But I
Because
can
you
make
don't want to step into that inquiry as a final arbiter of that fact.
Indeed.
Because it's an interlocutory finding.
Indeed. But I can make submissions, my
You
lord.
may. Yeah.
Thank you. And I'm going to put it as bluntly as I can. Both accused 1 and 2's credibility was shredded. And I say so for the following reasons. What we were told in their plea explanations changed. What we were told in terms of instructions that were put to state witnesses also developed. Then, when the accused took the stand, those instructions or their evidence further developed. Now, my lord, it's this simple. If what you're saying is the truth, there would be absolutely no reason why the evidence would change. And that's the state's strongest argument, that the credibility of these witnesses certainly were of a poor quality, and I'm being very kind when I say poor. With the exception of one, the defense witness that was called, my lord, the state will argue, was an honest witness. And I say so for the following reasons. Her evidence was that accused number 1 had walked past her. It was a few seconds. In that time, the probabilities of her making an observation, state will argue, is very minimal. But she was honest enough to concede that as soon as Mr. Apollo stepped out of her sight, she can't say what would have happened to him. And I even put to her the suggestion that Mr. Apollo could have fallen, Mr. Apollo could have been smacked by Mrs. Smith. She can't say. So I will argue that that witness's integrity is intact and her evidence may be accepted. And that is it, my lord. I think I'm under my 5 minutes.
No,
Safe to say?
You're over your 5 minutes, but you've got a lot of time left. Just shows you how long 45 minutes is.
Indeed. Indeed. But my lord, state's position is, state has discharged the onus. It cannot be argued that these statements were not freely and voluntarily made. I mean, the explanation, see, now you've invited me, so I will talk some more.
If you want to stop, by all means.
My lord, the accused legal rights, and I'm referring to accused number 2 specifically, 5 times was what I counted when he was informed of his rights in terms of that notice, 14A. Accused number 1, at least 3 times. So it cannot be said that any of these accused were not aware or properly informed of their rights.
Now I'm going to interrupt you, because fast forward, with allegations of pre-statement, undue influence, torture, to put it lightly, that's the allegation. Then you have the next phase, and it applies to both of the deponents. You would realize I prefer not to refer to the persons as accused.
Yes.
Because in this inquiry, it's an inquiry as to the statement, so it's the deponents to the statements. I prefer to do that, but people that are used to litigating in criminal courts, it's so easy to refer to people as accused 1, accused 2, accused 3. I try as far as possible to stay away from it. But you've got those allegations. We had Mr. Harmse and Ms. Nkabai set out the basis upon which they will allege it's inadmissible. So phase 1 is Seaborder, Dr. Nell, Mr. the Colonel Pretorius. Right? That's your chain. So far as it relates to accused number 2, lift, Jacobsbaai, Seaborder, Dr. Nell, Colonel Clark, Dr. Zimri, Captain Siakui. That's a sequence, right? So you have oral evidence on both sides. Insofar as it relates to phase 1, let's call it phase 1. That's the police involvement. You've got neutral evidence, phase 2. You've got oral evidence but supported by real evidence on the final phase. Except insofar as it relates to Mr. Van Ryn, it's both Clark and Siakui. See, I should speak less. So my question is, when a court evaluates evidence, title to have regard to the demeanor of a witness. It's not the be-all and end-all. And yes, one have to take regard the standing of that person and the level of engagement you can have. So forget about, because you've already made your point about the two deponents in the witness stand. You've made brief submissions on the others, but they are professional witnesses, so to speak. Talking about the police officers. But their evidence should not be seen in isolation. What is the weight to be attached to the real evidence? And those are the exhibits, exhibits 2 and 3. It's the video recordings of the statements being taken. So there you can pick up demeanor. You can pick up the conduct of the interviewer, the police officer. Because of the challenge that there's this undue influence and so forth, and it's carried through because you're of the same institution. You represent SABC. Olden days, when the magistrates took it, the challenges were not as vociferous as now. It normally went up to the door of the magistrate, but separation of powers dictated that. Because this morning we had an example when your colleague was asking questions to Mr. Van Ryn. And I'm sure a lot of people in the courtroom were surprised because they couldn't hear the audio when it was played. But if you then go beyond just what you see prima facie, and you look at it, then you might draw conclusions. Now I'm asking you, as a court, in evaluating that evidence, how much weight does it carry in this inquiry?
Incredible, my lord, because as the court indicated, this is real evidence. What better view does a court have than to actually observe for itself the demeanor of a party? So, state submission, serious weight. I can't guide the court as to percentage, but my lord, definite weight can be placed on this evidence alone. Because it's real. You can't argue with what we saw, what we heard, what we observed.
Because remember, I gave you all these steps and all the components, because one can't evaluate the real evidence in isolation. It's got to be evaluated
Holistically.
holistically. But quite clearly, often you have certain aspects that weighs heavier. It's not all feathers in this bag. There are some stones as well. And which are the stones and which are the feathers?
We'll get there eventually. My Lord, if I may just add, what if we didn't have the video? Then all the court would have is the document. Look at how much more that real evidence adds to this court's mind when it comes to that determination, and as the court said, a holistic view. So how much more or how much better is it now that we have the video? In fact, I think Colonel Clark should be going around giving all officers lessons about how confessions must be taken. When we observed his conduct, when we observed the extent he went to. If we didn't have the video, my Lord, all we would have had is his document. We wouldn't have seen what he had done. If that answers the question.
Well, if you didn't have the video, insofar as it relates to Mr. Apollos is concerned, you wouldn't have picked up the manner of speech of Colonel Pretorius
100%.
by not necessarily using the words in the document, but breaking it down sometimes to slang words to try and explain.
Indeed.
Hence, I'm asking you the question because I've actually re-looked at all the videos. I've zoomed in on them. I tried to distill the words better. And it gives one a different picture if you do that.
100%, my Lord. We would not have observed from Mr. Apollos how he leans in and observes when Colonel Pretorius is writing. And then he pauses, he nods, and he carries on.
Well, if this matter was heard in Cape Town, we would have had the facility of just plugging in and putting it on the big screen in court.
Yes, my Lord.
Because we have the facilities there. Here we had to do with a screen. Maybe something the OCJ must think about, because I don't think this is the last case where we need to take justice to the people.
Indeed, my Lord.
Yes.
Those are my submissions. I have nothing further. I may have something in reply, but those are my submissions.
Now, if subject to what comes out, because you've only used 15 minutes, of which I've taken 7, Ms. Nairo Chetty agrees. I might give you a little bit more time at the end if you need that.
Thank you,
Mr. Armse, you want to take a break first, or are you ready to shoot?
I'm ready to shoot.
If you're ready to shoot, in the words of the late Judge Fagan, when we used to sit together, we sat together in one or two matters before he retired. He used to say, "Skiet moenie wag nie." Mr. Harms, you, just for the record, during the course of this trial, you also gave me a legal article.
I did, my Lord.
Of, I'm trying to get to his surname now. Don't want to mess it up.
It is D Delta L-E-A-L-L-Y. It is an article that appeared in the Potchefstroom electronic law.
So I read the article. And if you want to refer to it, you may. Because it deals with, if you want to refer to it at this stage, you may, simply because I read the article.
Yes.
It's an article that deals with admissibility of evidence in the constitutional era. And there's one case, for example, the Erasmus mentioned in the first case, that's not me.
I gathered that, my lord.
But there's another one, Saunders, where that's me. But the other one, the Eastern Cape one, is the other Erasmus. But it's tried now that whatever we do, and particularly when it relates to the admissibility of extracurricular statements, it needs to be viewed through the prism of Section 35 of the Constitution inter alia, and not as in the past, looking blindly at the provisions of the Criminal Procedure Act. And that's most probably simply because the person didn't know the Constitutional Court had so many years ago pronounced on it, still tell the public, the South African public, that the High Courts don't know what they're doing. Yes. Thank you.
My Lord, I've taken the liberty to just draft a very short 6 pages.
So you can start his clock now. Thank you.
Sorry,
Thank you. Yeah, you can give me the heads. I'll go through it with you. Thank you.
May I hand up
Certainly.
one to my learned colleagues?
That just means he wants to force me to take an adjournment after argument. No, that's fine, Mr. Adams.
No, my Lord. My Lord, this is just a concise points. It's not really an argument, it's points in respect of the law, not the evidence and everything. This is dealing with the law.
So 1 and 2 we've dealt with. The onus, that's right.
Indeed,
and then I see you refer to the article of Ali, Dean Ali, from Northwest University.
I would just, if I may, go through the rest just briefly, my Lord. There are 2 other matters I also refer to that it also comes up in here, but I'll, if I may just go through this very quickly, my Lord.
Certainly.
Yeah, under the onus of proof, we've dealt with the onus of proof. I just wanted to, for completeness sake, mention the matter of S versus Lawrence, Gorky, and 2 others, my Lord. High Court of South Africa, Eastern Cape Division, Tata, Port St. John Circuit Court, my Lord. I'll skip the details. In paragraph 24, it is tried that in establishing whether a statement amounting to a confession complies with the provisions of Section 217 of CPA, the onus rests upon the state. Proof of admissibility of the confession must be established beyond reasonable doubt. And then the next paragraph goes to state with the Zekali. It says Supreme Court of Appeal. Sorry, no, that's the Gauteng Division Pretoria matter, my Lord, with Cox AJ. In August 24, at paragraph says the burden of proof rests on the state to prove admissibility of the confession.
Just one moment. Yeah. Mr. Adams, we just missed the fact that Ms. Pulani is sitting behind the accused.
Sorry, my Lord.
Ms. Pulani is sitting behind the accused. Because we're interpreting softly in Afrikaans to Mr. Apollos and Mr. Van Rijn. So,
I'm aware of that.
are you keeping up or not? Yeah, are you keeping up? So, if you can just give me a sign. No, I just wanted to alert you that there might be a sign.
Thank you, Mark.
That to slow down or not. All right. Thank you.
The next matter I'm referring to, paragraph 5, is the statement of Zekali. My Lord, I'm not going to read that in paragraph 4, all of that. It's all about the proof, which you've now dealt with. Only the last sentence of that mention in paragraph 4 is that it was not the duty of the defense to prove that he was, in fact, assaulted. And in paragraph 11 of that same matter, notably, the state did not call any of the alleged assailants to confirm or deny the alleged assaults. Considering the nature of the evidence, it could not be difficult for the state to establish the identity of the police officers who transported the accused, and in this matter from Actonville to Brakpan. And in paragraph 7 continues, the accused denied that he made the statement freely and voluntarily and testified that he continued because of the previous assaults and being scared and nervous because of it. Then I'm dealing in paragraph 7 with section 35.
I don't want to take your time, but of course, what's in paragraph 6, the quotation, that's not a statement of law.
Which one is that, number one?
Paragraph 6 on page 3 of your heads.
Yes, my lord, which is?
The quotation from this, is it Zikali case? It comes from paragraph 11 and 12 of Zikali's case. That's not a statement of law.
That is not?
That's not a statement of law. That's a statement of fact.
No, it is a statement of fact. It is actually the events that happened in that matter. Mm. And I will argue just a little bit later, conclude to that it is similar to this matter.
Yeah. No, I can see that. I can see the connection, but just I just thought I'll...
Yes, it's not a statement of law, my lord, indeed. Paragraph 7 then refers to the article that your lordship has referred to of D. Ali. In dealing with the provisions of section 35, expresses that the rationale for the existence of the exceptions relevant to admissions, confessions, and pointing out is in the main a lack of voluntariness, as well as the reliability principle. Paragraph 8, does it change? Section 35(5) changed the golden rule that applied whether or not the evidence obtained in relevant to the issues, and if this was in the affirmative, such evidence would in general be admissible. Section 35(5) reads, and I will just for the sake of completeness read it, evidence obtained in a matter that violates any right contained in the Bill of Rights must be excluded, and the admission of such evidence would render the trial unfair or otherwise be detrimental to the administration of justice. Then section 35(5) assessment consists of a balancing exercise.
Just to give you an example, if for example, and one of the issues that were complained of the morning we were in chambers, I think it was the 30th of March, was the intrusion of the media in the space where attorney-client privilege may be breached.
Yes, ma'am.
I can't recall, it's many years ago. It's one of the first big poker cases in the Western Cape High Court, where I actually acquitted most of the accused on the basis that I found that they couldn't have a fair trial because attorney-client privilege has been breached. And so the evidence becomes inadmissible because of a constitutional right that doesn't necessarily fall within the jurisdictional requirements of 217 or otherwise common law for the admissibility of admissions or confessions. Hence I said it is now trite that when a court approaches these questions that it needs to be viewed through the prism of the Constitution, and anything that does not pass that test, which generally can be described as fair trial rights,
yes, my lord,
then a court should exclude it. So although it's challenged on these two bases or three bases in the one instance, in this exercise, I still have to consider whether it does not infringe on the accused's right to a fair trial. So the 35 rights inter alia. But one also has to look at the general principles of the Constitution in the determination whether it passes constitutional muster.
Yes.
And I want to say to you that I'm alive to that test.
Yes, my lord.
Thank you.
Thank you. I just want to, for sake of completeness sake, then also mention paragraph 9, the section 35(5) assessment consists of a balancing exercise where the factors should be weighed and balanced against other relevant factors before a court may decide whether either to admit or exclude the disputed evidence. I apologize for the typing errors, my Lord. It was late last night. Of interest is the approach followed in the matter of S versus McKenzie. That's a 2011 1 SACR 554 KwaZulu-Natal judgment, my Lord, at paragraph 51, where Governor Sami AJ referred to the automatic exclusion of unconstitutionally obtained evidence and reasoned as follows. I am in agreement with the learned Patel J. in Viljoen's case. There is no discretion afforded to a judicial officer when he/she is confronted with a situation where evidence is obtained unconstitutionally. To admit such evidence, contaminated as it is, will be a violation of the accused's right, and above all, will be prejudicial to the administration of justice. Paragraph 11, my Lord, is it is submitted that when determining whether to exclude or admit unconstitutionally obtained evidence under Section 35.5, notice should be taken of the reminder by Chaskelson P. in S versus Makwayane. In the Makwayane matter, Chaskelson P., the Honourable Chaskelson P. stated at paragraph 88, the very reason for establishing the new legal order and for vesting the power of a judicial review of all legislation in the courts was to protect the rights of minorities and others who cannot protect their rights adequately through the democratic process. Those entitled to claim this protection include the social outcasts and marginalized people of our society. It is only if there is a willingness to protect the worst and the weakest amongst us that all of us can be secure that our own rights will be protected. My Lord, then I just want to also, and there's only one more reference here, the matter of S versus Songezo, Mini and 4 others. The Western Cape High Court matter is on review, automatic review with reference 141178, a quorum between Lagrange and Rogers JJ. The judgment in the automatic review on 30 April 2015, Rogers J. Lagrange concurring stated at paragraph 24, this judgment will hopefully serve as a reminder to persons involved in investing crime. I think it should be investigating crime, my Lord. Whether the public or private sector, that the courts will not tolerate the extraction of information by violence or threats of violence. As the present case illustrates, the use of unlawful coercion at an early stage of investigation may taint information which might otherwise have been elicited by more careful and restrained means, and may make it very difficult for the state to secure convictions. In Tandwa Supra, the court made the following observations at paragraph 121. We accept that the public flinches when courts exclude evidence indicating guilt. But in this country, struggle to maintain law and order against the ferocious onslaught of violent crime and corruption. What differentiates those committed to the administration of justice from those who would subvert it is the commitment of the former to moral ends and moral means. We cannot win the struggle for a just order through means that have moral authority. We forfeit the authority if we condone coercion and violence and other corrupt means in sustaining order. And in Tembu, this is still the...
So Tandwa, do you have the reference for Tandwa? Which court was that?
This was the Western Cape High Court.
No, but it was Tandwa.
Sorry, my Lord.
Was Tandwa...
Tandwa, I have it in the...
Because... This is the
I can give you
automatic review court.
It is an automatic review, yes, my Lord.
This is an automatic review, but they refer to Tandwa.
I have it in the matter.
I'm not sure that Tandwa is a... It would be in a footnote, I think.
The matter of Tandwa is S versus Tandwa and others, 2008, 1 SACR 613 SCA, my Lord.
Yeah. And whilst you're there, can you just get me the reference from Tembu, please?
The matter of...
It's in paragraph 26, the reference is in...
Yes, my Lord. S versus Tembu, 2008, 2. SACR 407 SCA.
Thank you, Mr. Aramsa.
I don't
Of
have
course,
copy.
that one, that principle in Mtembu was restated on numerous occasions,
Yes, my lord.
both in this division, but also in the Supreme Court of Appeal.
Yes, my lord. So, should I read that paragraph? my
No,
lord,
you
or
don't
is
need
it
to
not
read it.
necessary?
I'm actually aware of
Thank
it.
you. Thank you, my lord. I then undertook for myself to close on the legal position the closing paragraph of this article that has been referred to of D. Alley and the PERJ. My lord, the closing paragraph there, it deals, it follows on, and I'll start with the third last sentence in the previous paragraph. This seems to be the correct approach, since the regular excuse of unconstitutional unconstitutional police conduct becomes because the evidence is essential for a conviction on serious charges would only revive the public perception which existed before 1994, that the police are above the law. And in the final paragraph, I would like to quote, such public perceptions may be detrimental to the integrity of the criminal justice system. To be sure, the regular admission of evidence obtained in blatant disregard of constitutional rights, which evidence is important for a conviction on serious charges, runs counter to two important principles. First, the never again principle, which was endorsed by the Constitutional Court as one of the fundamental tools that should be employed to interpret the provisions of the Bill of Rights.
Does he quote in the footnote, does he give you that, the endorsement of the Constitutional Court in that article?
Sorry,
In the article.
In the article.
Does the author give you the authority that he refers to for the never again principle?
It's, I think it is referred to by Ferreira versus Levine, Freyhoek versus Powell.
No, but Ferreira versus Levine,
Yeah,
that's
that-
old authorities. I'm asking whether in the article he gives us the Constitutional Court authority upon which he says that was endorsed. It doesn't.
It might, my lord, but I am.
It's an academic article. I would have expected a footnote. But either as it may, it was clearly stated in Chabalala. I remember I don't think anybody else here were practicing at the time. They were all too young. But that was the police docket case in Chabalala. It was the dictum comes from Muhammad DCJ, as he then was, or DP, I think it was still called DP. The first Constitutional Court. Remember the
Yes.
two cases dealing with the A part of the docket, and then the whole big debate about whether you're entitled to the diary, and because in our days you never got the docket. We had to read the docket through the cover because we didn't get the statements, and we had to learn to cross-examine on that basis.
Lord, yes, as to the reference, it's probably referred to in the article. I didn't want to go through the whole article.
Yeah, no, I read the article.
Okay, yes.
I just found it interesting. I found it's interesting and it's quite helpful for persons to understand, because we still find, like the so-called legal expert that I saw on television, on the news nogal, and for people to understand, when we apply the law, it's the never again. We can't go back. We've adopted a set of values.
Yes, ma'am.
And whatever we do, we need to measure it against those values.
Yes, ma'am.
And if it be that a guilty person go free, then so be it.
Yes.
But courts must be careful not to just lightly just grab where people grab at straws. You need to look at it from a value-based analysis. So I found it very helpful. I also found it interesting because of the university where it was penned. So I didn't know they had a very strong constitutional law school.
Yes, one of the
it was published.
One of the professors, I think it's Professor Kruger, that was part of it. I think it was.
Seems he was teaching at Pretoria at the time.
Yes, I think it was Professor Kruger. Yes, I think it was Professor Kruger that was part of the writing of the new constitution.
Yeah.
Yes. If I may, my Lord, then just as I said, firstly, never again principle.
How far are you from done, Mr. Harms? I'm thinking whether I can maybe take a deep breath. I just have to step outside this room.
I can put it on ice, my Lord.
I'm just going to go outside that door, get some fresh air and come back in.
May it please the court, my Lord.
Court adjourned. Irritation. But if I can, I don't want too many adjournments, so hopefully I'll be able to sit it through till the end of your argument, then we'll take a short adjournment and then we go on with Ms. Ndibay. Yeah.
If I can, the second, the two important principles, the second one is the directive of Section 35.5 that in challenges under Section 35.5 our courts must defend the integrity of the criminal justice system. Then, in the matter, my Lord, and I'm going off this, there's the matter of, and I think I'm referring to it in my short heads, the GCAM matter of Alfred Zwelithumile. It's GCAM. It's a double barrel, GCAM, and the state. It's the Supreme Court of Appeal of South Africa judgment. A quorum between Kachalia and Shongwe JJA and Gorvin AJA, my Lord.
So it's recent.
It's case number 1034 of 2013. So 1034 2013 judgment was given on the 25th of March 2015.
Yeah, no, it's. Well, I'm saying it's recent that.
Yes.
I'm looking at the names. Although, yeah, 2015.
Yes, my Lord. I just want to refer to paragraph 48 in that judgment. It is not necessary to deal with the evidence of the police in any detail, and this, as we know, at the SCA, it's an appeal.
Well, you mentioned 3 judges to me.
Yes, it is Kachalia and Shongwe and Gorvin.
And Gorvin AJ at the time.
Yes.
AJA at the time.
At the time.
So it was before Shongwe became the DP. But it's one of those, the fact that it has 3 judges, it means it will most probably have come from the Thohoyandou court. To most probably have come from the Thohoyandou court.
I cannot see offhand here, my Lord, where
Just give me the judgment.
Transkei.
Where does it come from?
Transkei.
Yeah, then it was in the system for a very long time.
Yeah. Yeah, from the Transkei.
You see, the situation was there were these special arrangements where matters from the old TBVC courts went directly to the SCA. And that's why it has the 3 judges. So, but of course, by 2012, 2013, it was only the old Botswana courts that still went to the SCA, because I was there at the time, so I know the arrangements. Yeah.
Lord, I want to mention paragraph 48 because I see the relevance to this matter, as my learned colleague for the state argued, and much was made of the fact that accused 1 was, I can't remember the word that was used, destroyed or shredded, my Lord. Shredded, his credibility was shredded, my Lord. I want to read paragraph 48 in this judgment. It is not necessary to deal with the evidence of the police in any detail, and I accept that the learned judge was correct in finding that much of the appellant's evidence was untrustworthy. But I think he too readily accepted all the evidence of the police without properly analysing it, and did not properly consider those aspects of the appellant's evidence that were reasonably possibly true, despite his mendacity. In fact, the judge misdirected himself by approaching the evidence of the appellant on the basis that he, in brackets, and his co-accused, needed to put, in inverted commas, put up credible version to refute the overwhelming, strong and convincing evidence of the police regarding the admissibility of the confessions. All that was required of the appellant was to present a version that was reasonably possibly true, and even if it contained demonstrable falsehoods.
I'm not going to take the bait of commenting.
Sorry, my Lord.
I'm not going to take the bait of commenting.
I'm correcting myself, my Lord, because I see my note says I must read paragraph 49 as well, my Lord, if I may. I must read my notes on. Paragraph 49 says, when confronted with confessions made by suspects to police officers while in custody, even when those officers are said to be performing their duties independently of the investigating team, courts must be especially vigilant, for such people are subject to the authority of the police, are vulnerable to the abuse of such authority, and are often not able to exercise their constitutional rights before implicating themselves in crimes. Experience of courts with police investigations of serious crimes has shown that police officers are sometimes known to succumb to the temptation of extracting confessions from suspects through physical violence or threats of violence rather than engage in the painstaking task of thoroughly investigating a case. That is why the law provides safeguards against compelling an accused to make admissions and confessions that can be used against him in a trial. My learned colleague, and I'm going to not go through all the evidence. I have a couple of references I want to make in respect of the witnesses for the state that gave evidence where they contradicted themselves. I don't consider it quite necessary, but if the Lordship would like me to, I can do that for the sake of completeness. What I just want to start off with is that what I understand from my learned colleague to argue is that the argument around the injuries of accused 1, I'm going to talk about accused 1 only, and the evidence of the Dr. Zimri and the evidence of Dr. Nell, which I respectfully also submit was incomplete, the examination.
But Dr. Zimri had no role to play with Mr.
Accused
Pollis.
Yes.
It was only Dr. Nell.
Yes. But Your Lordship will remember I did ask a question.
No, you
in
did.
General, yes, in general. And in general, the submission from a learned colleague is that if what the accused says happened, they would have had a lot worse injuries, fractures or whatever. My Lord, so my question is, what bearing does that have on the evidence? If there are injuries, if there is more than a reasonable possibility that the accused was injured, coerced, irrespective of how serious the injuries are, and irrespective of whether the doctor completely understands and is properly put in position to make a proper assessment of that, if it is reasonably possibly true that the accused was coerced, was injured, was assaulted, and that is the reason why the so-called confession was made, and all the statements were answered in the right way, and all the answers given as was expected to do, then it still amounts to a contravention of Section 35(5). And I submit that it is irrespective of whether the contents of the confession was the accused's own version or a combination of what the accused says had been prescribed. My submission is that it is trite. If it is reasonably possibly true, and I submit that it is more than that the accused one had been assaulted, then his constitutional rights in terms of Section 35(5) and Section 217 had been violated. I just want to, for the sake of completeness, as I said, I didn't want to go and outline how the mainly two witnesses for the state, Captain Lombard and Sergeant Fortuin, contradicted themselves. But I do want to refer to one or two aspects, and specifically in relation to the following, and I'll get to the injuries shortly. Captain L's statement, Exhibit BB, at paragraph 62, it says that
I'm listening.
On Monday 2024/0304, late the afternoon, the investigating team collected Kelly and Buddha at Wiki's by Hotel Saldanha. The team found Stefano in Diazville and brought him for further interview. My Lord, that is what's in Captain Lombard's statement. His evidence in chief said that Kelly was brought, he saw Kelly was brought to sea border. And then Your Lordship had asked him, and what about Buddha? And he says that he heard, he did ask people, there were other officers. His evidence was, toe vra ek oor Buddha en was verwys gewees na seaborder kantore. Now, that, in his evidence, he first said Kelly and Buddha, then he corrected, and then he says, no, Kelly was brought. That is in direct conflict with his statement, Exhibit BB, paragraph 62. He knew, but in his evidence in chief, he doesn't admit that he saw accused one there as well. Then Captain Lombard's evidence in chief, he says, ek let op dat B se linkeroog was geswel en 'n bietjie blou. And after that he said, he gave evidence that he asked the accused one what happened or if he was assaulted, and the accused one would have told him En Captain Lombard's evidence was, hy sê nee, nie aangerand nie. My Lord, I can go to Sergeant Fontaine's evidence as well, where he also, and your Lordship will recall, said right from the beginning that he saw accused one had a blue eye or a red eye or an injury on his eye. If one views that in light of the evidence that was given by the witness on behalf of accused one, who had nothing to do with this matter, who clearly said she saw accused one. And when she was cross-examined about which side you saw of him, she clearly said, I saw his left-hand side. He walked past me. I saw him clearly. He had no injuries. She didn't. And then asked about the side, the left-hand side, and if I submit, if accused one had arrived at sea border with the blue eye, she would have seen it. Now, my learned colleague's suggestion that either Kelly or somebody would have injured him between the hotel and sea border is just, as everybody else and my colleague also uses Afrikaans statements, is wensdenkerij, my Lord. It is, there is no basis upon which to assume, and if it is assumed, it has no value to assume that there was a possibility, however small it is, that accused one could have injured himself between the hotel and sea border officers. I submit that is just unacceptable. Well, then my conclusion to that is that Captain Lombard wasn't talking the truth to this court. It is not possible for him to have seen that accused one had a blue eye when he arrived there at sea border. It is a matter of minutes from the hotel to sea border, and they were in a vehicle, and there is evidence from the state that they were collected by Sergeant Korba and Constable Korba and I think Sergeant May. Two ladies transported him.
Is the description of a blue eye meaning the eye was blue? Or that the subdural bleeding had already gone dark? Because remember,
yes, my Lord,
we saw the close-up.
Yes, yeah, it was.
It looked slightly swollen and yes, the lighting was not the best, but I'm not sure whether one can describe it as a blue eye, no. In the sense that it was dark already.
Yes, the doctor's description was much more scientific, and I can't, at this moment, will not try and utter those words, but it was an eye, and we could see on the video that it was hurt internally as well. There was a redness as well inside it, my Lord. So it's just not a normal blue eye as when somebody bangs at something against it. And Sergeant Fontaine jumped on the same wagon and said yes, when he saw him, he had an injury to his eye. That could not have been open, truthful evidence to this court, my Lord. Then Captain Lombard and other witnesses for the state gave evidence about the accused having been transported from Seaborder that morning after he was arrested in the car to Saldanha. There's Exhibit GG, which your Lordship will recall, if that was so, which accused one denies, there was no booking out of them from Saldanha police station. So the question is, were they really booked in, because they were never booked out to go and have the confession done. Accused one clearly says, I was not taken there. I was taken from sea border to the doctor, from the doctor back to sea border, and that's where I did the confession. That's also borne out by paragraph 88 of the affidavit by Captain Lombard. After completion, paragraph 88, after completion of the interview with Kelly, and all three of them were transported to police stations in the West Coast District for detention. There is no evidence that supports that, no credible evidence that supports that, as accused one that said from sea border after the confession he went back for medical, and from there he went to Live Black. My Lord, I am not going to be any longer. My submission to this court is, the question is there a reasonable possibility that accused one had been injured and assaulted? He was crippled, that could have been seen on the video of the confession. His eye was definitely swollen, and it was pointed out that his right hand was swollen, and I leave it to the decision of the court, and submit that accused one's rights were clearly violated, irrespective of his credibility, and that the admissions, what he made, should not be admissible. May it please the court.
I don't want to get into the debate on that last submission. I think that's an issue we need to, if we go beyond the challenges made to the freely and voluntarily and etc., sound and service senses and so on, undue influence. Because you will recall there was a judgment in this division which indicates that the admissibility requirements for extracurricular statements
that were recanted.
Those are whether it should be included. Right? So the state bears that onus. And then if it's a 35.3 or a 35.5 challenge, one looks at the exclusion. The question then arises is if you want to claim the exclusion on the 35.5 or the 35.3, how do you deal with it? Of course, the court came to the conclusion, ultimately it remains a value judgment. But it can be an interesting debate. I'm not going to waste my time with it now, but on that last submission that you made, one can debate it all day long.
Yes,
on the law, on that point, but not on this Thursday afternoon. Yes, thank you, Mr. Adamson. So it's 12:49. Mr. Kabai, you up next, but the warrant officer just indicated to me the food is here. Paul, if we take a 20-minute break now, will that be enough time so that, because Mr. Kabai has to move his stuff this side and books and so forth, and at the same time the accused can have something to eat? 20 minutes? I'm looking at them. Everybody nods but for Mr. Van Ryn. He's normally very eager to nod. Maybe he's tired. All right. 20 minutes until 10 past. 10 past 1. In the meantime, you can get me the warrants. I'll do all the warrants, warrant officer. So the moment we're done this afternoon, then you can hit the road. Good. Court adjourned.
All right.
Put this on again. Somebody just assist Mr. Kabai with the microphone. That's okay like that? Thank you, Mr. Kabai.
Thank you, my lord. Kabayi, and I represent Mr. Van Rijn in this matter. Okay. Mr. Van Rijn instructs me to object to the admissibility of a statement that is termed confession on the following reasons. We submit that it is not an unequivocal acknowledgement of guilt. When it was taken, he was not in sober senses and sound mind. It was taken against his will as he was unduly influenced. My argument, my lord, the first part of my argument will be supported by two cases. State versus Ori.
State versus? State versus?
State versus Ori, my lord.
Ori.
Ori. Cape Town.
Yeah.
Yes. Judge Bozarek. It's a 2005 one, SACR, at page 63. And the other pages, my lord. The second one, it will be State versus Sebejan. State versus Sebejan and others. 1997 one, SACR. Thank you, my lord.
Yep.
We were told by Mr. Lombard that the reasons behind the interviews were to clarify discrepancies and inconsistencies from Mr. Van Rijn's previous statement. He was called. The previous statement he was referring to was never produced before Mr. Van Rijn. He gave the information of what took place on the 19th of February 2024. No discrepancies were brought unto his attention. Now, going back to these two cases that I've just quoted before this court, a person, I'll put it that way, a person who appears before a police officer for interview has constitutional rights. Before I go to those rights, my lord, today it is the duty of the state to prove beyond reasonable doubt that my client was not unduly influenced, that my client was not assaulted before the taking of the statement. Now, going back to the cases I've quoted before this court, I'll refer this court to the case of State versus Ori, my lord. Mm-hmm. It was stated in this case And I like this case because the first person who gave evidence there as the investigating officer is Kenneth Clark. But that time, he was still a captain. It's a Bishop Levis matter. It was stated in this case, at the material time, the accused was neither an arrested, detained, nor an accused person, but merely a suspect. He was therefore entitled to be warned of his rights. Now I'll go to the case of State versus Sebajan, my lord. In this matter, the court considered whether a suspect could lay claim to the rights enjoyed by arrested, detained, and accused persons under Section 25 of the Interim Constitution. Judge Satchwell, in this matter, expressed the view that although the Constitution was silent with regard to a suspect's right, such a person indeed is entitled to fair pre-trial procedures. I will pause, my lord, to submit that my client, his rights, his pre-trial rights, while he appeared before Sergeant Fontaine, were never explained. I continue, my lord?
You may. Remember, there was the whole debate around how it should be approached. I'm talking about interim constitution phase up to 96 and then thereafter. And that's where Nombewu and so forth arose. But we passed that now, and I think, as Mr. Arms had set out the law, that's how, what the law is. Although the person that's been called for an interview, let's accept that, it's been called for an interview, when it comes to the incriminating part and the statement being given, all the rights that will eventually lead to the fair trial rights, they are to be taken into account. So it's a much broader approach than what it was pre-93, 93 to 96, and thereafter. Yes. So for some other reason, the authors have decided to also discuss the different phases of the development. It's important to understand that development, but I think we've now gotten to the point that it's crystallized. But I'm with you, and I'm aware of Ori's case as well.
Sibajan.
Yeah, of both the Satchwell one and that one, and Ori the Bozilic J one. So yes, I'm with you.
Thank you, my lord. Satchwell J expressed the view that although the Constitution was silent with regard to a suspect's right, such a person is indeed entitled to a fair pre-trial procedures. She held further that these include the rights that which would accrue to an accused person when arrested. She mentioned those rights: the right to remain silent, the right to be informed of a right to remain silent, and the right to be informed of the consequences of making any, the right to choose and to consult with a legal practitioner, and to be informed of this right promptly. During my cross-examination, my lord, I put to Sergeant Fortain whether at least he has cautioned my client. Not to explain the rights per se, just to caution him, because he was about to put some questions to him. He said no, he didn't caution him. There is the recent matter. This matter was decided on appeal, Estate versus Mtetwa.
Which one? Which one? Which Mtetwa?
Mtetwa, I don't have the full citation, my lord, but I'll give one.
And
when I'm continuing with my argument.
I'm asking you specifically which one, because there were a few Mtetwas. Is the one decided in our division?
Yes, my lord. I should think so.
Did you check who the judges were?
My lord?
Did you check who the judges were in Mtetwa?
When I'm arguing further, my lord.
No, you.
Okay.
You refer to Mtetwa. I was the presiding judge in one of those, and I'm not sure which one you're referring to. That's why I'm asking.
I will clarify that, my lord.
It was a full court decision.
Yes, my lord.
Yes.
In this matter, my lord, Judge Pickering concurred with Sangoni J.
No, that's the one in the Eastern Cape.
Yes, my
That's
lord.
one
Yes,
in the Eastern
that is the Eastern Cape one. Thank you, my lord. Sangoni J. Concurring, they found that a suspect was entitled to be cautioned or warned before questioning.
Now, I know what does the judgment say about that each case should be determined on its own facts? The Eastern Cape judgment, I'm asking you, does it deal with that question?
Ori is dealing with interrogation. Ori, the facts of Ori, the Bishop Levy's matter, is very similar to our case, my lord.
No, I'm aware of the Ori case. But the point is, yes, there are certain requirements, but as I have it, the overriding factor is always that each case to be determined on its own facts. So there's no hard and fast rule of a line in the sand, because you will often find there are those ones that can straddle both sides, and it's still, especially at this stage, where the last time I checked was that the principle is each case to be decided on its own facts. It's not a black and white. You might have these hybrid issues, and then the court must make a decision that's fair and just, having regard to the jurisdictional requirements. But I'm with you, and yes, there are authorities that suggest a very narrow interpretation. There are others that say go slightly wider. When I determine the admissibility at this stage, and I want to stress at this stage because it's interlocutory, court should exclude evidence that's obtained in an unlawful manner, whether it be on constitutional principles or otherwise. But courts must be careful because it's interlocutory and take care that one, you look at the bigger picture. And the bigger picture of not necessarily, as in this case, we blended in from the main case into what happened on the 4th of March. But you would have realized in the consideration, and I'm taking some of your time, I'll give you more time, what was imported from the main case into the trial within a trial were those statements of the 20th and the 29th came in, Lombard's views on how he perceived the contents of those statements, having regard to the consultation that took place, or the interview, or engagement with Mr. Apollos and Ms. Smith in Vredenburg. So those are all factors that play into, was it necessary before I, in his words, clarify your terms, interrogate the caution of rights. It's a judgment call I have to make. But I'm alive to those issues. I just want to put your mind at ease.
Thank you, my Lord.
Thank you.
What I like from the principles in both these cases, my Lord, they emphasize the principle of fairness. Will it be fair if an interviewer is just interviewed without being questioned first? I like that principle. I'll just refer to State versus Ori for the last time, my Lord, then I'll move on. State versus Ori, Honorable Bozalik J stated that, in my opinion, the admission of such statement obtained without a warning that it may be used against him or her will inevitably taint the fairness of any subsequent trial. Before my client was asked by Sergeant Fontaine, please tell me, what happened on the 19th of February 2024? There was no warning that whatever you are going to tell, it can be used against you later
Well,
in the case.
Now the converse can also be argued, and more particularly the portions that was put to Mr. Van Ryn this morning by Ms. Swanepoel. Because the ultimate statement, the statement under attack here, and yes, one can't you can't look at it in compartments, but the statement under attack here is a statement made to Captain Seekwe in relation to Mr. Van Ryn. Now he sits with Mr. Seekwe, Captain Seekwe, and over and above what's on Exhibit LL, there are those discussions between them. So we know there's we park for a moment what happened in C border office. Get to the car. Johnson gives the SAP 14A. He's well aware of it and he conceded this morning. because he takes it out of clock. Strike one, says the state. Then he goes to Clark, whose evidence you would like for the defense because he did the right thing. So he says, yes, you have that one, but I have to explain to you again, you know this pink slip? I'll give you the pink slip. Now we're going back to the real evidence. And then he explains and explains and explains and explains, and then hungry man with pain, I don't feel comfortable. Go and rest. Okay. Come back to Sekwe. Sekwe explains, yes, he didn't write everything down, da 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 da. Again, rights explained, but now it doesn't end there. We're only dealing with rights explained, right to a legal representative at this stage. Now they come into an engagement, and this happens between pages 15 and 16 of 26. Somewhere there it happens. And now as the discussion says to him, you know, I've explained to you, I know you said to me it's fine, but are you sure? Do you still want to continue? You know, you can get a lawyer. Now, in the context, looked at it holistically, on the facts of this case, even if ordained, and I'm not saying that that's the ratio for any finding I will make, we're just debating it currently. Fortuyn, let's accept, although Fortuyn says, you know, when the crunch came, when we realized there was something up here, I explained. And then Lombard came when he said, now you must detain them, explained again. But let's accept it didn't happen for argument's sake. Will that be fatal to their admissibility a la Ori? The facts in Ori were very different, weren't they?
My Lord, at this stage, trial within a trial, the onus hasn't shifted.
No, the onus hasn't shifted. I'm asking you about the facts. These are the facts we're dealing with here. And I've given the accused all the credit for the negatives on the state side, talking about sea border. But what were the facts in Ori? The facts in State versus Ori. The case that was before Boslik J.
State versus Ori, an accused person, that time didn't know if he was an accused person. He was called by Captain Clark to the offices in Bishop Levis. Offices in Bishop Levis, he was interrogated. But Captain Clark, in evidence in court, maintained that I explained the rights to accused. I explained his right to legal representation. I explained his right to remain silent. Now, the issue there was whether, before he was interrogated, was he warned that you are a suspect?
But aren't the facts different here? The facts here are on the state side, and then I have to make a call. And I'm going to summarize the way I see it. You have a missing child inquiry registered on the night of the 20th, going into on the 19th, going on to the morning of the 20th. Now, I said I'm not going to give reasons for my ruling, so what I'm saying now shouldn't be taken as reasons. I'm just giving this as a summary, the way I see the facts. because it's an interlocutory finding that I'm going to make. So the facts might be clarified at a later stage during the course of the trial. Missing persons inquiry registered either late on the 19th or early hours of the 20th. By lunchtime on the 20th, child is not been found. Milstein and Sigobe, who were responsible, Milstein and Sigobe, unfortunately I've got the mask on, but I just don't want to cough. Milstein and Sigobe, out on their work in the Swartland, gets called back. They arrive in Middelpos. It's confirmed the child is still missing. First port of call, go to the house of the child. They find Mr. Apollos. Tells them about Rens. He says nothing about Steveno. Constable Sigobe goes around to Rens. He gets a statement. Rens speaks of Steffi. Also gives a reason for why Joshlin didn't go to school that day, and gives a timeline. Remember, at that stage, what's also in the file is Gongota and his colleague that were on duty on the 19th that interacted with Miss Smith. Or their report is there. The statements were typed much later for the police docket. So they've got that. Then they obtained a statement from Miss Smith. And things didn't fully add up, including whether the child had a cold or whether the clothes were dirty, inter alia. But there were a few things that didn't tie up. And the timelines didn't tie up. And then Captain Lombard decides, after engaging with Sergeant Milstein, let me clarify with Ms. Smith and Mr. Apollos, because at that stage Mr. Van Ryn was seen by the police on the 22nd. But he was, as they would say in Afrikaans, tik getik. So they didn't interview him. We're sitting on the 25th. Yeah. The Sunday at Vredenburg. Office with a glass, big glass petition. He speaks to them. Mr. Apollos is evasive. He defers to Ms. Smith. Still can't clear it up. Wants to chat to her, nonchalant. That's his take on the matter. Nobody speaks about really the concern. He doesn't see the concern in them. He smells a rat. Then there's social media things going all over. And people are saying things and this and that. And then Stefano's statement is obtained on the 29th. But now they're here because they're partaking in the search. They decide whether they were ordered by Brigadier Nana or not. It's of no moment. We've got to get them all in. Let's talk to them. The other dramatis persona, namely Rens, is in Cape Town because they had to flee. That's the narrative. So the three that are here, let's get them in. But there's timelines, there's this, there's that. He gave us a whole shopping list of problems. And for the sake of time, I'm not going to repeat them all now. So, gives instructions when we're done tomorrow afternoon. Those people must be here. I want to talk to them because we need to find this child, they say, the police. Fast forward. Mr. Apollos, Mr. Smith is there. Mr. Apollos, Mr. Van Rijn is there. Ms. Smith is downstairs with the females. They first asked them a few things. Didn't come. They said, nah, let's try something else. Let's split them up. Now, nobody's making anything of it now. I thought people were going to make something of it. But then, eventually they decide, because they've now done these many lines of investigation, so they know the people they know who they're dealing with. Not everything was spelled out in detail in the trial within the trial, because Captain Lombard says, we knew about the tight bond between Kelly and Boeta. I've seen it myself there in Vredenburg. I can see what's going on here. So they decided to go to your client, Mr. Van Rijn. Some people might say they duped him. But that was the strategy, says Sergeant Fortuin. Says we go to him, we say to him, listen, you're in big trouble here. This is a serious case. And you know those two, they will dump you. If push comes to shove, they will dump you. Because by now they said, nee, go ask Kelly. Boeta says, go ask Kelly. Now they tell him, listen, they're going to dump you. Because they're not going to drop each other. They're going to drop you. And that's how they cracked it, they say. I'm talking now about the police. Then the mistake the accused makes, they mention Malima. Now they go and they bring Malima. And now they go from one to the other. This one says that one says that. Oh, he's here, he's doing this, until they cornered them on their stories. That's how it played out according to the police. And then, I don't know, hartskoon maak, waarheid praat, uitkom in die sak patats, those Afrikaans expressions. But now it escalates. But the moment they were saying something more than I know nothing, Fortuin says, then I cautioned them. I said, hey, be careful. And then when they now brought in Malima into the mix, then Captain Lombard says, sluit hulle toe. Let's detain them. Now we'll formally do their rights. Now they have a sleep. Let's accept for the moment they slept in the car.
Thank you, my Lord. I appreciate... Oh,
right? Let's
sorry.
accept they slept. Then we get to the real evidence.
I appreciate, my Lord, the summary by the court. And I further appreciate that the investigating team in this matter didn't only have one option to bring the suspects in court. They should have followed the criminal procedure normal route of investigating the matter first. Now they choose the route that violated Mr. Van Ryn's rights. Now to answer the court regarding the explanation of rights, I would like to take this court at 4 a.m. in the VW Polo in the morning. I want to take the court to Sergeant Johnson.
Sergeant Johnson.
Yes, Sergeant Johnson. But before I go to Sergeant Johnson, I will take the court to the manner in which we were told our client were put in these cells. With due respect before this honorable court, one must also be mindful of the fact that the conduct of the police from the time of the signing of the SAPS 14A, that at that time, all three suspects, Mr. Apollos, Mr. Van Ryn, and Ms. Smith, they were not at the same place at that time. But funny enough, the SAPS 14A that has been filed off record is indicative of one time, 4 a.m. How is that possible?
The explanation given, whether it's acceptable on procedure or not, is another issue. The explanation given by Sergeant Johnson was she first did the admin, she first filled it in, and then she went to each one of them. Whether that's a proper manner of doing it, that's maybe a question for another day. The crux of it is not the time, because it's not in dispute between the state and the defense in the trial, within the trial, that both Mr. Apollos and Mr. Van Ryn were served with these documents. In fact, we saw the proof thereof, because coincidentally both of them took their papers out to the people that took their statements. So they were well aware of it. And yes, if we use that to attack her credibility, and you want me to make a credibility finding, that's of course another different issue. To say, well, she lied because these documents were not proper, and then you go look at the SAPS 10 and you see what's going on there. And then you look at the cell register, the so-called cell register, which also has a 14 number, SAPS 14. You see how that was jippered, but not everything there is her handwriting. For example, the date of the 6th was written in by somebody else. You can see whether they work on the basis of that was the time they were being charged, although they were charged at another police station. I don't know how that works. I know it's not supposed to work the way it was done here. But does that change the complexity of the application that we have before us?
My Lord, the point I want to make before this honorable My Lord, the point I want to make before this honorable court, still on that issue of rights, is that my client instructs me that, I'm sorry, my Lord, it instructs me that.
No, it's okay. You can point your fingers. That's a manner of the way you speak. I've got no problem with it, right? As long as you don't point it at me. then we might have, but I understand, Mr. Kabai, when one argues, some of us speak with our hands. I sometimes do it too. Some of us will put the finger up or so. Don't panic about it. Don't worry about it. I understand. I stood there in my time, although it was many, many, many years ago. And I was accused often that I was very animated, throwing my spectacles around and things like that. So don't worry. Yeah.
Thank you, my Lord. Given the manner in which this SAPS 14A was signed, one would wonder as to when these rights were explained to the accused persons, taking into account that they were not in the same place at that time. Sergeant Johnson. No, stop there, my Lord. My argument is my client's rights were never explained. Sergeant Johnson did not explain rights to my client. The only thing she did, my Lord, is to produce that SAPS
14A.
14A for my client to sign. That time my client was sleeping. He was woken up and he was instructed to sign. At that time, he didn't even know what he was signing for. That is the submission we're going to make as far as the rights are concerned, my Lord. There's the other issue the court has touched. There's the other issue the court has referred me to accept the rights.
Well, there was the overarching issue was obviously the rights. Pre-questioning, post-questioning, pre-detention, post-detention, pre-statement, in-statement, all of those stages. But the contentious issue that you raised were the ones with Fontaine and Johnson. You've covered that now.
Thank you, my Lord.
So you can move on to the next issue.
I'll go to the issue of the medical reports.
Is it EE? I know the second one of Zimri is LL.
Yes, my Lord.
I think it's EE and LL. But I know which ones you're talking about. Dr. Nell and Dr. Zimri.
I'll start with Dr. Zimri's, my Lord. When she was testifying, she suggests that my client should have displayed more serious injuries than shown or than those that appeared on the medical report. I would like to point one thing to this court. Dr. Zimbri's evidence is clear.
Ms. Nkabai, just give me about 3 minutes. I'm just going to step outside. And secondly, I must talk less. I must just listen to you.
Oh, not opening there.
Yes,
Okay.
thank you. Thank you.
I am Dr. Zimri's evidence, my lord.
That's LL.
Yes. I would like to point one thing to this court. Dr. Zimri's evidence is clear, my lord. She testified that the injuries that my client showed to her were new injuries. New to her, they were within 24 hours. This supports our contention that my client was assaulted as early as around 3 p.m. on the 4th. Was it the 4th?
Fourth.
Yes, on the 4th of March 2024, my lord, including the 5th of March 2024, the morning of March 2024. Point number 2, Dr. Zimri did not undress my client. She was not sure whether he had long trousers or not. As we sit here today, we shall never know if my client had any injuries on his body. But we have seen him struggling to walk and to sit during the taking of the confession. Although we advised that he was taken for an X-ray, the defense was never finished with the X-ray reports or X-ray results.
Well, it seems that it's in any event of no moment, because the X-rays were requested by Dr. Nell in the morning, and that had to do with the knee, because he had a previous, the X-rays were requested by Dr. Nell in the morning because he had a previous operation on the knee, and then there was some swelling. So that's how I understood the evidence, and it was to avoid any further damage to the knee that he then ordered the Robert Jones bandage that was then placed on the knee, and that was the cause of that knee being immobilized, so it couldn't bend properly. You will recall when Captain Siekwe testified, I raised it with him that Mr. Van Ryn was dragging his leg because he couldn't bend the knee, because I knew at the time, because of the doctor's evidence of the bandage, because on Dr. Nell's evidence, the bandage was placed on the knee of Mr. Van Ryn after he left Dr. Nell. So it was only when he got back to Dr. Zimri that she saw it and noted it. And she made a point of it that in the report that she did not remove the bandage. And in the evidence she said, I did not remove it because it was a fresh bandage and the purpose of it was to immobilize the knee. So I accepted that the X-ray would not tell us anything, because that's because of the the old operation scar on the knee that was now swollen. So there was some trauma to it. What it was, that is in dispute. Thank you.
Thank you, my lord. I wish to draw this court's attention to the location of the wounds on arms and knees area. I heard the state leading Dr. Zimri on pressure points and the like, but nowhere did this doctor testify that the injuries she observed could not have been sustained in the manner accused has shown in this court. When she was testifying, my lord, she testified about possibilities, and she mentioned those possibilities. If the court can remember that.
I'm with you.
I'll go back, my lord, to where I started and the court took me to. Yes. State versus Zuma, state versus Ori, state versus Sebejin, and state versus Memani. All of these.
So there was Memani and Melani.
It's Memani, my lord. Memani.
No, I know. There was a Memani. There was also a Melani at about the same time.
Okay.
Dealing with the same issue.
Okay. All of these cases, my lord, with due respect, they cry trial fairness. If the accused is not warned before questioning, that failure, that violation will render the trial unfair. I will read, my lord, a few judgments from the cases I just mentioned before this court, and what also our Constitution demands. Our Constitution demands that the accused, those without status, like my clients before this court, be given a fair trial. Fairness also demands that an unconstitutional obtained, that will be my argument later, an unconstitutional obtained evidence be excluded. But before I go there, my lord, I will go to the case of State versus Zuma. It's a 2004 case, my lord. In Zuma and others, it was stated that the right to a fair trial embraces a concept of substantive fairness and justice. This approach is endorsed by the authors of the South African constitutional law. They observe that unless the Constitution's pre-trial rights are extended to suspects as well, the investigating authorities could simply leave potential accused persons in the category of suspects, thus enabling themselves to collect evidential material from the unwary, the unsilent, the unrepresentative, and unwarned suspect. My client, while he appeared before Sergeant Forte, He was not silent, he was unsilent. And as unsilent as he was, my Lord, he was both unrepresented, both unwarned. This will be the argument of the defense.
Listen, Kabai, you've been on your feet almost an hour except for the short periods that I went out. You've been on your feet almost an hour except for the short periods that I had to leave the room. But so you need to wrap up, cover the other points as well, because you've been busy almost an hour.
I will leave this point, my Lord.
Yeah.
I will go to the second point.
Certainly.
Before 1994, police would exercise unlimited powers. There were no checks, there were no balances. And that legacy, seemingly, it is brought to this democratic era, my Lord. I'll argue this point as follows.
Yes.
The policemen in this matter they testified that they had a strategy. This was in the testimony of Brigadier Anana, in the testimony of Captain Lombard, and in the testimony of Sergeant Fortain, that they had a strategy. And that strategy that they had, my Lord, was solidly, wholly, in total, to violate my client's right.
On what basis? On what basis?
On the following basis, my Lord. Sergeant Captain testified that he has explained some rights, some constitutional rights to my client. What
No,
time
but we've moved off that now. We're now with a strategy. Now I want to know, what's wrong with that strategy?
I'm trying to explain the strategy, my Lord.
Is your accommodation booked for tonight? Yeah.
Yes, I still have it, my Lord.
Because we might sit tomorrow morning as well. Because I've given you 45 minutes, given you latitude, so you must get to the point, cover the points, everybody else at the same time. Prosecutor didn't use theirs. The starts were shorter. If you're still on the first point, then you're not going to get through your 45 minutes. And I thought you had heads of argument. I saw my registrar printing something. I didn't look at it. I just thought it was the heads that she printed.
I couldn't hear the...
No, I thought you had heads of argument.
Yes, I do have.
Oh. No, I just, when I was upstairs, I know that she printed something. I didn't see what it was. She just said to me she's printing heads of argument, so I... But you need to get a move on.
I'm moving on, my Lord.
Yeah.
My second point is that the evidence that was obtained from my client to be excluded on the following, my Lord. Sergeant 14 testified that it was around 11 when he explained the rights to my client. It was already late at that time. He has already got information from my client.
But you made that point already. You referred me to Ori and others.
Captain Lombard testified before this court that he explained the rights to my client at about 2 a.m. This is my contention, my lord, before this court, that those rights, if indeed they were explained to my client, they were late. And in those rights, the rights that Captain Lombard told this court that he explained to my client, he never explained to my client that he has a right not to be compelled to make a statement. And that right is critical and fundamental in this matter. I will refer this court to the following case, my lord.
Mm-hmm.
The Honorable Judge Falam in State versus Matonzi, it's a 1996, Volume 1, SACR 78, said the following.
1996?
1996, my lord, it's Volume 1, SACR, at page 78.
I saw it in the Tui at another time when I saw it in quoted in the Tui when I was going through this the other day. So yeah, I'll find it. And that's a Cape case then. That would be a case of this division. Matunzi would be a case of the CPD as it then was.
The CPD. I can't hear the court, my lord.
That Matunzi would be a decision of this division.
Oh, okay.
The CPD as it then was.
Yes, it's Cape Town, my lord.
Yeah.
It's Cape Town. He said the following. The rulings given by the majority in the Irish case of the People versus O'Brien, 1965 R142, on this question and the reason therefore should be followed in this country. What did the Irish court say? The Irish court ruled that where there has been a deliberate and conscious violation of the constitutional rights by the state or its agents, evidence obtained by such violations should be in general be excluded. Section 35(5) of the Constitution provides that evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. This Honourable Court is thus expected to make a value judgment as to whether the admission of the unconstitutional obtained evidence will render the trial unfair or would be detrimental to the administration of justice. Our South African courts over the years enumerated factors to be taken into account in considering whether the admission of evidence would be detrimental to the administration of justice or not. I pause, my lord, to make reference to the case of R versus Collins, 1983, 5 CCC.
Just give me the reference again.
I'm sorry, my lord. R versus Collins.
R versus?
Collins.
Collins.
Yes.
Why must I go look at a foreign case where we've got so much jurisprudence here on this point?
It's an authority, my lord, and I love
no, you might love it, but we've got lots of South African authorities.
I'm going there. But even this one
I know that Rex versus Collins was quoted somewhere.
Okay.
That I know it's actually Resigner versus Collins. because there was a queen in the office at the time. But it doesn't help, Ms. Kabai, to just give me names of cases because it was quoted somewhere. For example, if one looks at the Matunzi case, for example, you will find it has a long run-up to that time, because what happened was that was still the interim constitution. So constitutionalism was alien to us in our jurisprudence. So in fact, it's a constitutional imperative that we do. But on these basic principles, if I have to look at it at the end of the case and it becomes really necessary, I will do that. But I told the parties earlier on, what we're dealing with here today, we're dealing with facts. I need to decide the facts first. It doesn't help to throw English, whatever the English lords have said to me. I'm not interested in that now. I have a good summary, actually a very good summary, in a South African textbook referring to South African constitutional law. With all due respect, it's nice throwing around names of cases. Sinkabai, you haven't appeared before me in the past, have you?
I did, my lord.
Where?
Cape Town.
Which court?
I can't remember, but it was a civil matter from Kraaifontein.
Motion court or?
Motion court, my lord.
Now, normally, I think it's only Mr. Haramsa and Ms. Herman that have appeared before me in the past. If counsel would quote like you quote now, I would ask you to give me the facts of the case. And I would ask you to take me to the page and the paragraph number where the ratio is. But I don't have time now, but don't tempt me. I'm not going to do it now, but don't tempt me by just throwing cases at me. Because I will go, and I will go and research the cases. And if argument comes on the final issue of this case, of these points, I would want to know every comma and full stop in the case. Because it's so easy. You would have seen since day one I've had these 3 books here. But of course we fortunately have access to electronic libraries as well. But on these matters that we're dealing with here now today, it's not even a lot of pages. Because a lot of it that's here is irrelevant in this textbook. And it summarizes the points neatly. It's updated because it's a loose leaf publication. But if you want me to go to the king and his people, take me there. But I'm going to take a short adjournment. Let me just go fetch my computer and switch on the router for me, please. Just going to get my laptop, switch on the router so that when I bring my laptop, it's on. Then we can go and visit Westminster with pleasure. Take a 15-minute adjournment. right, Ms. Mkabai.
Thank you, my lord.
Let's
Now I
take
will
it away.
deal.
Which is the first one you want to take me to? I'm waiting. Which is the first case you want to take me to? Is that microphone not working?
Thank you, my lord. Now we'll deal with the facts of the case. It is the contention of the defense, as was shown.
No. Take me to the case you want to refer me to, so that I can open it up.
Or
so
state
that
versus
we
Colin.
can have a sensible engagement. You're over time, but this is the way you want to do it. Let's do it. Take me to the case, give me the reference. I will open up the case on my laptop, and then we'll have a sensible debate. I'm waiting. Or don't you want to go there now? Because I know you've got heads of argument.
I can't hear the court clearly, my lord.
I know you've got heads of argument.
Yes, my lord.
You are way over your time. But you don't want to listen to me. Now you want to refer me to cases, which I'm not sure whether you've read the cases. So if you want to do that, give me the reference of the case, give me the name of the case. I will open the case in front of me, and we'll have a sensible discussion about the case.
My lord, I said now I will argue the facts of the case.
Of our case?
Yes, this case.
So you wasted my time for getting my laptop and getting a lead and setting up. You put out the challenge, I accepted your challenge.
Before the court adjourns, my lord, I knew I would go to the facts of the case.
To our case. Now get to the facts of our case.
Yes.
If you're just going to deal with that, I'm going to give you 10 more minutes. Finito. You're way over your time.
Okay. I'll be fast, my lord.
Next time, don't waste my time again like this. Like this.
My apologies, my lord. It is the contention of the defense, as was shown during cross-examination of the state witnesses, that Mr. Stevino was assaulted and threatened and intimidated by police. That during such conduct by the police, suggestions were clearly thrown to his face in an intentional strategy crafted by his abusers. And according to my instructions, as shown during the testimony of the witnesses, statements to the effect that he must tell the truth, and they, the police, knew that he, together with accused number 1, took Joshlin to Malima. The scenario started strictly after he was picked up under the pretense that he was being given a lift by the police, and ended up at Jacobs Bay Beach, where he was assaulted. And these suggestions were made to him again when he arrived at sea border officers. As if the torture at Jacobs Bay Beach was not enough, the torture continued at sea border officers. And it continued the whole night until the early hours of the morning.
I'm listening.
I personally find accused number 1 to be very strong and resilient, to have endured such long hours of the night while being tortured. The state has underplayed the effect of this unrelenting interrogation of accused number 2, the psychological pressure he must have been subjected to. A young man who unfortunately has no personal means for ways to have provided himself with the best protection. This man was taken against his will by the members of the community on about the 29th of February 2029. He was brought before Sergeant Sofobe. A statement was taken from him, and Sergeant Milstein didn't see any reasons to charge him, nor to detain him. He was released. Is taken again in the streets at or near Fredenberg Saldana hiking spot by the police. He's not told that he's under arrest. He's not even told that he's a suspect for that matter. During the interrogations, he repeatedly told the police that he was innocent. He insisted on his innocence, but the police didn't want to hear that he was innocent. It is therefore my humble submission that, with the respect that this court, after listening to all the evidence tested before it, in this trial within a trial, should be comfortable in making a finding that police acted improperly in getting Mr. Stefano making the statements which are the cause of this trial within a trial, and that such conduct on police was deliberate and calculated, and that their conduct was not a trivial technicality on their behalf, but a serious violation of accused constitutional right, not only to his bodily integrity, but violation of Section 335 in brackets 1A and C of the Constitution. And that, in the circumstances, this evidence should be ruled inadmissible.
Thank you, Ms. Nkabai. Any reply, Ms. Seremon?
No. Thank you, my lord.
I listened to most of the evidence over a protracted period until this morning. I have worked through everything. I'm going to take a 15-minute adjournment just to go and consider one of the cases I was referred to. Just want to go and open it up and have a look at that. It is now 14:42. I will return to the court at 3 o'clock and deliver my ruling. Court adjourned. So, this is an application by the state for the admission of statements made by Mr. Apollos and Mr. Van Ryn extracurrially. That means it was made outside of the court process to be admitted as evidence in the main trial. Customarily, one does not give reasons for the ruling, as it is an interlocutory ruling that may be revisited at a later stage in the trial. I thought it would be appropriate to just explain the process and where we are because of the public interest in the case, so that people understand what we're dealing with, what the ruling means, and to understand that this is not the end of the case. For evidence to be adduced in a criminal trial, it must A, be relevant to the issues in dispute, and importantly, it must be admissible in law. When individuals make statements extracurrially, like in this case, to the police, and it is claimed that it is inadmissible for non-compliance with the minimum requirements, the court has two choices. It can either be dealt with in the main trial, or, as we've done here, it is done in what is called a trial within a trial. It is a mini trial, and the only determination will be the admissibility of those statements. In this particular instance, on behalf of both Mr. Apollos and Mr. Van Ryn, it was averred that the statements made to Colonel Pretorius by Mr. Apollos and to Captain Seekwe by Mr. Van Ryn would be inadmissible, as it is a result of undue influence, assault, torture, non-compliance with the constitutional framework within which it must be adjudicated. It was further averred that the contents of these statements were not of their own, but it was rather recited to them by the investigating team. I have considered the evidence led both on the side of the state, who bears the onus to prove the admissibility of these statements, as well as the evidence adduced on behalf of the defense. I've heard argument today on these issues. However, I've cautioned the practitioners throughout, and more particularly in the last week, that they must get ready for argument. As I requested them to prepare, I did as well. So I was ready to make a ruling. going to make my ruling, and then I will explain what will happen further. Having regard to the evidence led for the admissibility of the statement made by Mr. Apollos to Colonel Pretorius on the 5th of March 2024, I rule that the statement can be admitted into evidence and be used as evidence in the main trial. Insofar as it relates to, so that will be Exhibit KK, which now becomes evidence in the main trial. Insofar as it relates to the statement made by Mr. Van Ryn to Captain Siekwe on the 5th of March 2024, provisionally admitted as Exhibit JJ in this trial, I rule that it is admissible evidence in the main trial and can be used against the accused. You would have noted that I've not referred to these statements either as confessions or as admissions. I do that deliberately, as I do not want to create the impression that I've prejudged the issue. There might be a lot of water under the bridge already, but there may be more storms coming. I don't know what they are. So we will adjourn this matter till Tuesday. First thing Tuesday morning, I want the state to address me in what is customarily done at the outset of a criminal trial in the High Court in terms of Section 150 of the Criminal Procedure Act. That will give us a roadmap as to where we're going. I do that so that we can plan, and we can plan our time. I have the full intention of attempting, as far as it within my ability and my powers, to finalize this case as soon as possible. It must, however, be understood that the state is dominus litis. They have the constitutional obligation to prosecute cases on behalf of the state, by implication the public. I cannot dictate to them as to what witnesses they call and how they call them, as long as we ensure that we finalize this matter efficiently. I will then give the defense an opportunity to consider the roadmap and the timeline set out, and then advise me during the course of next week what the plan is. Mr. Apollos, Mr. Van Ryn, Ms. Smith, you will recall what I said to you last night when we adjourned. I hope you have considered your positions and that you are ready to give your legal representatives instructions as to the way forward. You now know, particularly Mr. Apollos and Mr. Van Ryn, that these statements were admitted into the record. Lastly, what time do you start on Tuesday? Why 10 o'clock?
I know I'm probably going to be in the firing line, but since it's a long weekend and parties will be coming through on the Tuesday, may I humbly request 10 o'clock? I'm humbly requesting.
Let me hear from the defense. Ms. Nkabai, simply because you're at the microphone, do you have any views on starting time? They want to start at 10 because they say they will be coming through on Tuesday morning only because it's a long weekend.
I have no comment, my lord.
The same with you, Mr. Aramson?
I have no objection.
You've got no problem either way.
Either way.
Snyder Chetty, have you guys discussed it? 10. I've been overruled. So we're going to start at 10 on Monday. On Tuesday, because Monday is a public holiday. After that, rest of the week, because we're not sitting on Friday in this venue because the venue has been booked out for other purposes. We can't sit here, and I need to perform other duties in Cape Town. So it just worked out fine. Latest start in the morning is at 8:30, and I'm going to sit till 4. So from Tuesday, we're going to try and sit till 4 o'clock in the afternoon. If it's at all possible, if you can make inquiries, warrant officer, between Tuesday and Thursday, so it's Tuesday evening, Wednesday evening, Thursday evening. If we can accommodate closer, if it's not possible. But you will assist me? Yes. Thank you. We need to make up the time. I'm going to repeat the request I made to counsel a week or two ago. The week after that, we're also losing the Monday. It's an important public holiday, although the public holiday falls on the Sunday. But in terms of the law, the Monday is a public holiday, and I can't force people to work. If I had my way, we would have said. But I want you to consider again, we're going to sit Tuesday, Wednesday, and then Thursday is a public holiday, the 1st of May. I'm prepared to sit on the 1st, so that if we haven't finished the case, then we can make it up. Again, I can't force the practitioners or the SABC officials and other stakeholders to work on a public holiday. But I want to appeal to you. For those of us that come from Cape Town, I ask myself, what are you going to do on the Thursday? Are you going back to Cape Town for the day? It's a rhetorical question. So why not work? It might also be a gesture of all of our commitment. I don't want to put you on the spot, but think about it. Think about it on this weekend. It's sacrifices made. It's Easter weekend. So if it's within your means and within your ability, I'm prepared to work with you. For those of you that, the Christian people in the house, I think it's, from my staff, it's all of us except for Mr. Yankees. Have a blessed Easter. Hope you can spend time with your loved ones. And safe travels. Doesn't mean that those are not Christians, that in the true tradition of Cape Town, you can't have your pickled fish. Thank you, and again, thank you for your cooperation during the week. I know it's been tough. I know I've been a bit grumpy today, but I wanted to achieve what I wanted to achieve, and we did that. So thank you. Court adjourned.